We still do have 5 more minutes, but I'll just get my voice on the PA system so people out in the halls and such hear me and think maybe it's time to get back.
Here's how it happens in Santa Fe. Zach will talk, Kristen will talk. I haven't seen her yet, and then we'll have you talk, and then people ask questions.
Okay. Hey, Peter, how you doing? Good to see you.
Hi, Peter. Good afternoon.
Okay, it's 1:29 now, so I'm going to ask Christina to kick us off, and maybe you could do your own introductions and introduce yourself. Do you want a mic, or? That's fine. You can take this one if you want. I'll get this one.
Oh, sorry.
No.
All right. Hi, everyone. My name is Christina Martinez. I am a member of the Neighborhood Law Center. And this panel right now after lunch, no one fall asleep, we're going to be talking about free speech zones. So our panelists, to the my far right, this is Dan Crone. Dan is a lawyer who's been practicing here in Santa Fe since 1982. He focuses on criminal law, and he's been very highly rated by his peers, as well as received a lot of recognition for his work in criminal law. Right here to my right is Zach Chandler. He is an assistant city attorney, and he is also, like me, born and raised in Santa Fe, New Mexico. And in the middle is Kristen Greer-Love. She is with the ACLU of New Mexico. She is a staff attorney at the ACLU, and she focuses on the rights of immigrants, Muslim communities, and the incarcerated. So we're going to be talking about free speech zones. All right. What is a free speech zone? As you all know, the First Amendment to the United States Constitution says that Congress shall make no law abridging the right of the people to peacefully assemble and to petition the government for redress of grievances. Now, what free speech zones, they're something that's been created by U.S. case law. And basically what they say is that the government may regulate time, place, and manner of speech so long as the government does not regulate the content of speech. And this has been a big issue nationwide for the past year. So this was in May of this year. This is a headline from the Los Angeles Times. Frustrated with campus discourse limits, California Republicans take on free speech zones. And then you see the photo, and it is a guy who is not looking very much like a Republican. He's wearing a vegan shirt. And the reason was this article actually sort of covered how this idea of free speech zones creates strange bedfellows. So the guy who you just saw on the last slide, he's a 26-year-old. He's a vegan. He's a Democrat. And he was prevented from handing out leaflets on the Cal Poly Pomona campus, and these weren't political in nature at all. They were leaflets about the vegan lifestyle, and he was restricted from doing that by the school because the school had free speech zones set up, and you could only hand out leaflets in that area. So that's just one of the very many examples of what's been going on in college campuses. And then the second part of the article focused on a California state senator, 72-year-old Jim Nielsen. He's a Republican, and shortly after this incident with Nicholas Tomas, he actually carried a bill in the California legislature to dismantle the use of free speech zones across public areas, including colleges and universities. So both of them were fighting for the same thing. They were both motivated by the desire to ensure that people's free speech rights could be exercised anywhere that's a public forum, but they're very two different kinds of guys. And then we had the case of UC Berkeley. So UC Berkeley, probably most people would consider it to be the birthplace of the free speech movement in the 1960s. That's where it was all happening. But then now in 2017, Berkeley was under attack by the president and lots of other people because it canceled appearances by conservative speakers. Ann Coulter, Milo Yiannopoulos, who I never say his name right, but there was protests that these people were going to be speaking at this very liberal campus, and they ended up canceling their appearances, and then people came down on them because that's curtailing the free speech of the speakers, and that's not letting them speak in a public forum. So, of course, this was going to make its way locally, and it sure did in Santa Fe during our Santa Fe Fiesta, which is, the oldest celebration of the city. It celebrates how Santa Fe came to be, and there is a part of the celebrations that is controversial. Last year there was a protest for the Entrada, which is a reenactment of the Spaniards peacefully reconquering the city, which is an oxymoron in and of itself. And so this year, in preparing for the Entrada, the city took measure because they wanted to make sure that there was no violence. They wanted to make sure that, you know, there wasn't a huge mob on the plaza. And so what they did is they worked with the Santa Fe Police Department, who was working closely with the Fiesta Council, and they created free speech zones. Now, the Entrada takes place right by the Palace of the Governors, as you all know, in the middle of the plaza, which is a public forum. The free speech zone was outside the plaza, and 8 people ended up being arrested because they wouldn't comply with that, because they were exercising their First Amendment rights to protest. This is a headline from the Santa Fe New Mexican. Police feared large-scale public disorder at Entrada. That's from the end of September, right after this took place. And the article describes how city officials have maintained that because the Santa Fe Fiesta Council had a permit for the plaza, for the Entrada, that they were therefore able to have free, like unrestricted access to the plaza, and they could also restrict the access of other people. A police spokesman at the time said, it's their event, it's their plaza, so they can make the rules. And then the question that begs is, can a private party be granted unlimited discretion to suppress free speech in a public forum like the plaza? The 8 people who were arrested, this is a photo of Jennifer Marley. She was the one who was charged with both misdemeanor and felony charges following the protest. Mr. Crone represented her. The prosecutors dropped those charges on the eve before a hearing at magistrate court, but the charges were dropped without prejudice, and they can be refiled. 7 other people were charged with misdemeanors. Just very recently, all charges have been dismissed. The week of November 20th, charges were dismissed against 3 of them. And then the week of the 29th, charges were dismissed among the others. And Pro Tem Judge Yaliman, who's a municipal judge, she dismissed the complaints because she said that they were too vague. She said that they did not set forth sufficient facts necessary to give the people who were arrested notice of the criminal violation for which they were charged. But again, all of those charges were dismissed without prejudice and can be refiled. And that's where we are today. So what we want to do is we're going to hear from the city, and Zach and Kristen are both going to be telling us about the law in this area of free speech zones. And then we're going to hear from Dan Crone, and he's going to tell us just what the local criminal defense community has done, not just about the Entrada, but really about any kind of protest that takes place in our city. So I will hand it over to Zach.
Thank you. I'm Zachary, Chandler, Assistant City Attorney. And one of my jobs is to assist the City Parks Department plan for major events at the downtown plaza. But I'll start with 2 disclaimers. 1, I'm speaking on my own behalf. My words do not represent the official position of the City of Santa Fe. And 2, I will not talk about the specifics of people being arrested, because while their municipal charges have been dismissed, their lawyers on November 28 and December 7th had filed notice of tort claim. There's a pending legal action that may cover claims of assault, battery, false imprisonment, false arrest, malicious prosecution, and abusive process. I'm going to start my presentation with an attempt of a joke to actually relax myself. And it goes like this. I work for local government. Many citizens believe local governments don't seek clear and reasonable solutions. Many citizens believe local governments don't seek wise solutions or wisdom. In fact, when we see wisdom, we sue it. And you don't believe me? Well, the Court of Appeals recently heard a case captioned Town of Taos versus Wisdom. Look it up. 2017 NMCA 0066, Town of Taos versus Wisdom. That's right. We don't pursue wisdom, we sue it. Actually, it was Edwin Wisdom, and it was a DWI case, but it starts out as a joke. But due to the notice of tort, I'm not going to give you a blow-by-blow of the city's preparation for the Entrada, but I'm going to talk about the case law that is relevant to what local governments think about in preparing for such events, and I want you to pretend in the next 13 minutes that you're actually a municipal official. I also want to state the context of the time. Just weeks before the Entrada was the protest in Charlottesville. And on August 26th, the Washington Post ran an article titled, "How Charlottesville Lost Control Amid Deadly Protest." The article summarized the events that when the local police, they expected the white nationalists to be on the north side of the park on Jefferson Street, and the counter-protesters to be on the south side of the park on East Market Street. However, when things get a little stormy, the police moved the white nationalists from the Robert E. Lee statue south onto East Market Street, right into the path of the counter-protesters. And then the police, according to the Washington Post, stood not between the two opposing groups, but behind them and off to the sides. The Washington Post article quoted former Charlottesville Police Chief Timothy Longo saying, "How do you allow two completely divergent groups to come in contact with one another? In the current climate, this has all the earmarks of something that will happen again, and certainly every city should be looking at what happened to learn a lesson." Let me try to make an analogy, what local officials might be thinking about. Let's say I'm speaking right now and someone from the crowd comes up right in front of me and starts yelling, "The neighborhood law center should be banned," right here, right in front of me. And they're so loud, you can't even hear what I'm saying. So whose speech is more important? And what do you think Peter Dwyer, as the organizer, might do? This is a government building. He probably has a rental agreement from the government. Would he get up here and ask the person to be quiet so the other crowd members could hear what I have to say? Would he escort the person to a place where the person can interact with the other crowd members but not interfere with the conference? Would he call the police? And what if the person just sits on the ground and refuses to move and yells, "Free speech is everywhere! Free speech is everywhere!" The Entrada municipal case orders of dismissal are now public documents, and several of them have similar language, such as the criminal complaint does not indicate the location or boundaries of the private venue on which the defendant allegedly trespassed. It does not indicate the defendant knowingly entered or remained on said private venue. It is necessary for the criminal complaint to allege such facts are necessary to give the defendant notice of the criminal violation. The permitted property is not identified by physical location nor by its boundaries, nor is the permittee identified. So it appears that the local judge, and I'm sure other judges, are very interested in facts and circumstances, and these cases may turn on specific facts. So in my poor analogy of having a protester yelling at me right here at this conference, you've probably already identified maybe some different facts than a protester at the Entrada. And I'll let you guys think about that. But let's talk about the cases. Let's start with young Samantha Sustrick, go to Philly Pride, and then end up with the now new important Miranda case. And you'll note some of these cases were decided in the summer of 2017, just weeks ahead of the Entrada. But let's start with Samantha Sustrick. She was a high school student in the fall of 1992, and she lived in Strongville, Ohio. On October 28, 1992, then President George Herbert Walker Bush was coming for an important election or re-election rally, and the rally was scheduled to be held in the center of town property in a place called the Commons. The Commons was dedicated by the city's founders in the 1830s for public common use. It was used for festivals and art fairs, but the Strongville City Code allowed a party to permit or gain a permit to use the Commons. In this case, the local Republican Party obtained a permit from the city. It paid a fee to rent the Commons. The permit provided a description of what land was to be rented, and the permit allowed for a ticketing system where a citizen could apply for a free ticket for entry. The permit was, quote, limited to the members of the local political party and its invitees, unquote. So the local political party set the rules that only pro-Bush signs and buttons could be brought in. The local Republican Party, perhaps feeling that Bush the Elder was going to lose to Arkansas Governor Bill Clinton in Ohio, postscript, their fears were well placed because Clinton did win Ohio and did win the presidency, tried to pump up the crowd enthusiasm and size in this late October rally, and they had an offer for the local high schoolers. Come to the rally for free, you get to miss the school, no questions asked, and we'll have the school buses take you to the rally. Now, there was one flaw in this plan, and maybe in retrospect there were many flaws with this plan, but their main flaw was that high school student Samantha Sustrick took them up on their offer. She got on the bus with her Vote Clinton button and came to the rally. When she got to the event, the security asked her to remove the button, and she did. Meanwhile, at the same event, 2 adults also came to protest this Bush rally. They had gotten tickets and made it through security without anyone noticing their signs hidden in their jackets. Once inside, they held up signs that said, "No on Bush," and "The government has blood on its hands due to AIDS funding." These 2 adults were arrested. Both Samantha and the 2 adults did sue the city of Strongville on First Amendment grounds. That's Sustrink versus City of Strongville 99 F 194. And they argued the city could not issue a permit that converted the commons from a public to non-public area. The plaintiffs lost in the initial round and they appealed, and by the time they appealed, a key case had been decided by the U.S. Supreme Court. This case is Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston, 515 U.S. 557. This dealt with the South Boston Allied War Veterans Council, who were the organizers of the local St. Patrick's Day parade. And they had received a permit to hold a parade in the city of Boston. One group, the Irish American Gay, Lesbian, Bisexual Group of Boston, asked to be allowed to march in the parade. And the parade organizers said no. And of course, there was a court challenge that made it all the way to the U.S. Supreme Court. There, the Supreme Court held that the organizers of a parade could not be forced to include participants with a message that the organizers did not wish to convey. The Supreme Court concluded, when the dissemination of a view contrary to one's own is forced upon a speaker intimately connected with the communication advanced, the speaker's right to autonomy over the message is compromised. So back to Samantha and her team in Ohio. Well, the courts in the Strongville cases did look at this Hurley case and ruled that the government cannot force a speaker to propound a political message they disagree with. They told Samantha that she lost and that she could, quote, could have stood with her button on the sidewalk leading up to the rally to express support for Clinton. The courts also said those seeking admission to an area that was covered by the permit, which area was reasonably necessary to the organizers' expressive activity and was restricted to the use of the organizers and their invitees. The court will recognize the First Amendment does not prevent the city from issuing permits to groups seeking to make exclusive use of the commons for expressive activity during the limited period of time. So you might ask, why does the government even have a role in these type of topics? And the case law supports that the government interest is in crowd safety, crowd control, ensuring that the permit holder can use the permit for the purpose for which it was obtained. What are some examples of maybe the government overreaching? Well, so the case law says exclusion of attendees' ability to distribute literature or display signage is not narrowly tailored to focus on crowd safety. A single street preacher handing out leaflets can't be forced to leave an event open to the public. A single person handing out leaflets cannot be forced to leave the Columbus Art Festival, particularly when the art festival does not have a particular message it's trying to convey through the festival. And a single person handing out leaflets cannot be forced to leave a motorcycle rally at a Florida city park. What's the next big case? Starzl versus City of Philadelphia. Here the organizers of Outfest, which was a part of the Philadelphia Gay Pride Week, obtained a permit for a public event or a street festival. Protesters arrived with bullhorns, large signs, literature, and a documentary film crew. Their signs displayed biblical messages, many proclaiming their view that homosexuality is a sin. The protesters were around 20 yards away from the main stage, singing loudly, playing instruments, displaying large signs, and using microphones and bullhorns. Once the musical program began on the main stage, the Philly police instructed the protesters to move further up the street so not to block the stage or interfere with the activities, noting that Outfest had a permit to hold a program on the stage. The protesters moved north around 1 block and then stopped at a standstill in the middle of the street. One protester said, "We're not leaving," and directed his group to walk back towards the stage. The police warned the protesters that refusal to follow their directions could lead to arrest. Protesters refused to remove. The Philly police placed some of the protesters under arrest for disorderly conduct. One protester lay on the ground after being informed of the situation and declined the order to stand and had to be carried out. I will disclose that all the charges were ultimately dismissed, but the protesters then sued the city under the First Amendment. The court ruled against the protesters. It follows that although protesters cannot be excluded from the streets and sidewalks of Philadelphia where Outfest Festival took place, they are not free to proceed as they like through the permitted area. Quote, when protesters move from distributing literature and wearing signs to disruption of permitted activities, the existence of the permit tilts the balance in favor of the permit holders. Protesters did not simply carry their signs or distribute leaflets, but used loud bullhorns to express their message near the stage area, directly addressing an Outfest attendee in a confrontational manner. Because protesters were interfering with the permitted event's message, the police were justified in directing the protesters' movement away from the stage. Now, I'll note that these pride events do seem to be litigated frequently. There was a case out of Minneapolis in 2010, and as recently as Nashville in September of 2017, where that court ruled against the protesters and said the city has an interest in ensuring that a permit holder can use the permit for the purpose for which it is obtained. Is there a solution? Well, in the Minneapolis case, the court said, quote, although not raised by the parties in briefing, a compromise may be available. The Twin Cities Pride could designate a free speech zone on Pride Festival grounds, and police could enforce that area as a content-neutral restriction, assuming that those free speech zones provide attendees with ample alternative channels of expression. Attendees would thus have the opportunity to reach the minds of the willing listeners. Let me wrap up now with this 2017 case from the summer of 2017. This one's from Arizona. It actually starts back in 2006 when a pro-immigrant group held a rally in a Tucson park. And the protesters came, flags were burned, and there was a violent riot. Since then, the pro-immigrant group has held a rally and attempted to exclude the ringleader of the protest group. In their most recent application to the city, they said that they wanted to exclude people that want to disrupt the event. The ringleader was excluded from the event and was forced to stand with his bullhorn on the sidewalk across the street from the entrance. This is what I'm calling the new Miranda case because it's captioned Warden versus Miranda, 2017 Westlaw 3130664, and it was decided July 24th, 2017. The organizers of that rally had obtained an exclusive use permit for the city park, had advertised the event as open to those who shared the organizers' commitment to social justice and peace, and had fenced off a portion of the park. The court ruled against the protesters, saying protesters need not be permitted to participate in the rally by expressing discordant views, even when the rally is held in the public town commons. So I started with an analogy. It was probably a poor analogy. Sorry to pick on you, Peter. But once again, to wrap up where we started, I was speaking and a person in the crowd comes up right up here and starts yelling at me, the neighborhood law center should be banned. The neighborhood law center should be banned. And again, the person is so loud you can't hear what I'm saying. So again, what do you think the organizers would do? What different factors were discussed in the case law do you think would have more or less weight? Is this analogous or distinguishable to the Entrada situation? What facts matter? The location, whether it's a ticketed event, the permit description, my speech, the protester's speech, their activity? Should the person be removed? What kind of charge? Well, my time is up. You no longer have to be a municipal official, and as they say jokingly, you no longer have to be so stubborn that when you see wisdom, you sue it. Thank you.
All right, Zach, thank you. And so, he just highlighted how many things you have to think about as a governmental entity when you're trying to plan for something that you believe will cause some kind of protest situation. And now we're going to hear from Kristen from the ACLU to talk about the ACLU's perspective on free speech zones.
Well, thank you all for being here today. One of the first issues that I wanted to raise is something recent. After Charlottesville, there was a reckoning within the ACLU, and a reckoning about what it meant to defend certain people's rights to exercise their First Amendment rights, and what that meant when there were two different competing sides trying to express their views at the same time. And an article that I would really recommend that you take a look at appeared in Slate online. Dahlia Lithwick wrote it, and with someone else right after Charlottesville, but she said, at Charlottesville, the First and Second Amendments came into conflict and the guns won. And I think that that's one of the sort of other considerations that we need to consider when we're looking at First Amendment and civil rights. Now, First Amendment purists, many of whom are part of the ACLU and part of the leadership of the ACLU, will say if we don't represent odious views, the odious views of people that we hate, we risk dismantling a pillar of democracy, that being the First Amendment. Others within the ACLU will say, look, we've had a problem with racial justice in this country for a long time. And the historical subjugation of people of color in the United States has meant that the First Amendment, the value of it, is much stronger for powerful, wealthy, and white speakers than it is for speakers of color. So this tension between racial justice and the First Amendment, racial justice thinking about a society that is based on equality and equal protection, and the First Amendment as something that is essential to criticizing our government and ensuring that our government listens to the citizenry, is something that we continue to reckon with today within our own ACLU of New Mexico affiliate and within the national ACLU. And so in deciding whether to represent people, one of the considerations that we now have is weapons. And that's something that, of course, always should enter into a First Amendment analysis. But representing someone who is threatening immediate or imminent violence is prohibited under law. And not the representation, but rather that right doesn't exist for someone who's threatening immediate or imminent violence. And so weighing kind of the odiousness of the speech and the risk of violence is something that is at the fore of our concerns right now. Now, as a general matter, the ACLU views fixed zones where protest is banned as a real problem for the First Amendment. All too frequently, we hear of schools creating free speech zones and police corralling lawful protesters into out-of-the-way protesting areas where no one can hear them. The location of the message is so critical for the people who are delivering an odious or dissenting point of view. Such geographical limitations on speech, in our view, betray the values of the First Amendment, which permit and require the government to tolerate peaceful protest in public areas. We at the ACLU have repeatedly defended the right of, obviously, of even the most controversial speakers to get their message out. At the same time, there may be limited situations where protesters obstruct or intimidate people who are exercising their own constitutional rights. And we saw this come to a head in Charlottesville, where the facts demonstrate that aggressive protesters, such as the white nationalists that the ACLU represented in Charlottesville, inhibit Black Lives Matter folks from exercising their own rights. There are competing constitutional rights at stake. And we've seen these, some of the earlier comments mentioned this, but these fixed sort of buffer zones around abortion clinics is an issue, fixed buffer zones, particularly where Secret Service is involved when a president or a vice president is visiting a community. That's where we've seen some of the most vicious attacks on people's First Amendment rights. Again, the location of people being so important to the power of their message. I wanted to run through a little bit of the case law, but I did want to just talk a little bit also about the significance of the Entrada. So the protesters at the Entrada, some of you may know, three of them were members of the Red Nation, which is a group of activists, very young activists, who really have been extremely powerful in sort of talking about the rights of indigenous people in New Mexico and seeing New Mexico as an occupied territory and speaking publicly and very powerfully and thoughtfully about what that means when we're trying to confront a government that continues to oppress people of color, and particularly indigenous and Native Americans. The other members were of a group called Standing Up for Racial Justice, a white ally group that came in support of the indigenous people who were protesting, and they were also arrested. So we had, at the end, the Santa Fe 8, the 8 arrests at the Entrada, and again we saw this kind of sort of clash between the Entrada speakers who were on the stage and the protesters who were on the ground. And then there was even a counter-protester holding up a pro-Entrada sign, and we've seen photographs of him being allowed to remain in the non-free speech zone. So he was in front of the Entrada as a pro-Entrada protester, and then we saw the so-called other protesters pushed out of that prime space on the plaza. And given that the plaza is a historic space where people gathered to address, their government and address the grievances that they were seeking to ask the government to address, it's especially interesting to kind of look at this in the history of the subjugation and oppression of people of color, and particularly indigenous people in New Mexico. So in terms of the case law, so traditional public fora, of course, are places that by tradition have been open to public assembly and debate, precisely the kind of place that the plaza is. First Amendment scrutiny is strictest for restrictions that squelch speech on streets and in parks, which have immemorially been held in trust for the use of the public and time out of mind have been used for purposes of assembly. Here, too, at the Entrada, we saw a sort of confluence of interest. The city of Santa Fe has propped up the Entrada with financial support. They've provided police support. They've forgiven some of the Fiesta Council's debt in allowing the non-payment for police supervision that was there in prior years. And multiple courts around the country have rejected, precisely on these First Amendment grounds, the use of trespassing laws, which was the way that the city operated here, to exclude people from permitted events held in traditional public fora. Here, the Entrada was listed as a public event open to the public. There were no signs at the Entrada indicating that it was required someone to have permission to be there or a permit or a pass to enter. I've been to those events myself, and you easily walk into the plaza. No one stops you to make sure that you have a ticket. And that, in a way, distinguishes it from many of the other events that are possibly ticketed events. So we've seen a case, and I'll give you the citation, Galthright versus City of Portland, 439 F3rd 573. This is a 2009 Ninth Circuit case. The police, at the permit holder's request, ejected a man preaching in a city park during a privately sponsored city permitted event. They then intended to prosecute the man for trespassing. The court held that the man's First Amendment rights were violated by that police activity because a policy of allowing permittees unfettered discretion to exclude private citizens on any or no basis is not narrowly tailored to the city's legitimate interest. You may know from the history of this Entrada event this year, the actual Entrada event was moved. The time of the event was moved to an earlier time. It appears specifically to avoid this potential confrontation with protesters who find this event deeply offensive and really a rewriting of history that shows the Entrada or presents it as a peaceful event when in fact it was an extremely violent event that has had violent ramifications for centuries. Also in Parks versus City of Columbus, this is a Sixth Circuit case from 2005, a man tried to distribute literature during an arts festival on a city street. After the event sponsor told the police that the event sponsor did not want the man there, the police ejected the man and threatened him with arrest if he returned. The Sixth Circuit held that the city had violated the First Amendment in excluding the man from the event at the sponsor's request. The court explained in no uncertain terms that the city could not claim that one's constitutionally protected rights disappear because a private party is hosting an event that remains free and open to the public. And finally, in this trio of cases, McMahon versus the City of Panama City Beach, this is a Northern District of Florida case from 2016. There was a man who was attempting to pass out leaflets at a motorcycle rally in a public park during an event that was free and open to the public, precisely the same language we saw at the Entrada. Like the city of Santa Fe's justification for prosecuting the Entrada protesters, the police told the man that the organizer had the right to kick out whomever it wanted, and that the man had to abide by their rules. The police then threatened to arrest the man for protest. The court concluded that the city's stated policy of unquestioning deference to the whims of the permit holder in enforcing trespass statutes at a free and open to the public event is, to put it gently, troubling. The traditional public forum is the most quintessential, the most sacrosanct place for citizens to assemble, communicate thoughts, and discuss public questions. Here, when a private actor, just as here, the Fiesta Council is granted the unlimited discretion to suppress speech, whether based on viewpoint, content, or anything else, the public forum is eviscerated. And that's precisely what we saw here. It loses its essence. It ceases to be a place dedicated to the free and open exchange of ideas. And so it's really important to situate this case in the history of New Mexico and the history of Santa Fe. And I just wanted to mention briefly, the ACLU most recently has been investigating panhandling ordinances across the state of New Mexico. Panhandling ordinances are another place where we see attacks on people's First Amendment rights. We're seeing some of the most vulnerable people, often people of color, with no other means to gain income, who are asking for donations on the street or flying their signs, being arrested and harassed by police when they're exercising their First Amendment rights. So I would invite any of you who have clients who have been arrested for panhandling or flying signs to please feel free to contact our affiliate. We're very interested in challenging those laws. Thank you very much.
Thank you, Kristen. I think what we've seen from Zach and Kristen is that the case law in this area can go both ways, and it's largely dependent on the facts and exactly what happened in a particular circumstance. Sometimes the city is within its rights, and sometimes the protesters win. Now we're going to hear from Dan, and he's going to talk about something he created, a strike force, to deal with situations like this.
So I was working in my office on a Saturday afternoon in November of 2016, and I'm not sure how proud I am of that fact, but I started hearing some police sirens, and there were several of them, and my first thought was, my goodness, there must have been a bad accident someplace. And they kept getting closer and closer and closer. And then my office is on Sandoval Street, a half block from the courthouse. And then I started hearing voices and some chanting. And so I got up and went over to the window, and there was a protest that was going down Sandoval Street with our brother Aaron Wolf being among the protesters. And the juxtaposition of the date of this is that it was, I don't know, a week or two after the last election. And so people were very stirred up about some of the issues that had been raised. So the thought occurred to me that perhaps by the time they got to the plaza that somebody might get arrested. So I finished what I was doing for about an hour to give things time to percolate, and walked down to the plaza. And by the time I got there, everything had dissipated. So I started looking at my Twitter feed, and I saw that some people had been arrested. And so that's actually what the genesis of the strike force was. I decided at that point that I was going to assemble a group of the best criminal defense lawyers in Santa Fe who also believed in the robust exercise of First Amendment rights, and talked to them, and everybody agreed that we would represent people who were peacefully protesting who ended up being charged, and we would do that for free. So with the first round of people who were arrested, we parsed out the cases. The particular case that we had, the facts were that the woman flashed her top, and you know, particularly given the women's issues that came up during the course of the 2016 presidential election, we thought that that was appropriate free speech commentary. And ultimately, all of the charges against all the people who were arrested or cited, not everybody was arrested, ended up being dismissed. So things went along pretty quietly for a while, and then last September was when the Entrada happened, and so there, you know, as everybody knows, there were 8 people who were arrested in connection with that, and so the you know, the understanding and the pact that all of us in the strike force had was that you know, as peaceful protests happened and people got arrested, that over time we would continue to stay banded together and spring into action when necessary. So that's how the strike force was formed, and you know, basically what we view our mission as. We believe that, as I said previously, the robust exercise of First Amendment rights is something that is essential to democracy, and that it's something that we as criminal defense lawyers need to vigorously defend, because you know, as time has passed here over the last, I guess it's year now, well, no wait, 11 months of this administration, and some of the sentiments that are out there regarding the First Amendment, we feel that it's particularly important that First Amendment rights be vigorously defended, and that's what we have done up to this point and what we intend to do in the future. And so, you know, in terms of, I think that it's already been described here, the status of the Entrada cases currently, and so I won't go over that again. And I also think that the 2 prior panelists have, you know, laid out pretty well. I know it will come as a great shock to lawyers, but there are competing interests, you know, that keep us in business, and you know, and I think that everybody can see how it is that there are 2 sides to an issue, but our, you know, the mission of the strike force, as I say, is that we think it's important to keep the free speech rights of people as defended as possible. So I guess that's,
that's
what I have to say.
Right, and that's what we have presented for you all today, and we're willing to take questions from the audience at this point.
Okay, I'll start up here with Lynn just for my convenience.
First off, would you all mind getting those citations and the case law to Christina, so that then, because I was scribbling and I know I totally missed it. And thank you all. This is, it's good stuff, it's interesting stuff. I understand that in the wake of Charlottesville there was a lot of fear, and it's been interesting over this last year. Everybody's had to do a lot of re-examining, I think, of what these principles mean. I guess my question would be, in view of the increasingly vocal controversy about the role of the entrada in the city, and that it goes to the core of what the city of Santa Fe, many people in the city of Santa Fe believe is the culture of Santa Fe, while creating controversy for the reasons that we all know and you've discussed. Might it not be more appropriate to hold that as a cultural event somewhere not on the plaza, and think of the plaza as truly the plaza for all the people? Because I think even those of us without knowing the case law at all, and I did not, our first reaction was, you're kidding. You're actually using the police force of Santa Fe as like a private security force for a private organization. That's what it looked like to people out here, I think, a lot of people. And that was disturbing. And again, you know, it was kind of the wisdom thing. Is it time to move the Fiestas activities like that to another space and leave the plaza? I don't know. Anyway.
Sure. Of course, I can't answer that, but I can tell you that people of Santa Fe will have a chance to answer it. We will have a new mayor. The city attorney is retiring. We'll have a new city attorney. Traditionally, the new mayor selects a new city manager. The police chief left to Las Cruces. The Fiesta Council president is retiring. So there's all the policymakers. There'll be a new set, and so I imagine they'll hear from the people, and that'll be. I have no prediction on what they might do.
What do you think?
Again, that's beyond my level.
So there's an observation I think that I would have for this new group of people who are coming in, which is that on the Friday of Fiestas, it's been a tradition in my office that we all go down and have a pork chop sandwich at lunch and a Nutty Buddy. And so we went down there this year, and you know, there were multiple police on the tops of buildings around. Some obviously had guns. There were a ton of police that were on the plaza itself. And my impression by the time all the smoke cleared away was that that had increased and not decreased the tensions that were around there. And I recognize that it's you know, it can be a fine line, you know, as to what you do to prevent something like happened in Charlottesville. But on the other hand, my own personal opinion is that the way that it was handled this last time actually contributed to the tensions that happened on the plaza that day.
Okay, we've got a bunch of people. I'm going to work my way from the back because I tend to favor the people in the front a little too much, I think.
Great presentation. It's an issue that I worried about for the almost 25 years that I represented the state police, who end up doing security at the Roundhouse. Now, what happens when somebody decides they're going to protest in either the House or the Senate gallery, and you have the boys in black and gray have to remove them? Have they been denied their First Amendment rights? And that was an issue I worried about every year when the legislature rolled around. Thoughts, please. Thank you.
Okay, I guess my question would be to ask, or my answer would be to ask more questions. did you ever have someone say that it violated First Amendment rights? What were, the circumstances? Were certain ideas being expressed, and that's why people were removed?
All kinds of ideas got expressed. You had chants from up there. You had people come in with signs, and the state police response routinely was those people were removed and not allowed to remain. Amazingly enough, I never saw a tort claim notice in 24 plus years. But I always worried that it was coming. And it was my own personal opinion as in-house counsel for the agency that it was not a cut and dried issue. People could not be prohibited from expressing their free speech rights in those galleries. And if not there, where else do you properly get to address those legislative bodies? I mean, that's...
Well, right. I mean, that's exactly what Kristen is saying, right? Sometimes the location adds or detracts from the volume of the speech. And so, I mean, yeah, I guess it's just a very lawyerly thing, but I think it depends. And every situation under the case law is weighed by its specific facts and circumstances.
Okay, well, I think we had 3 other people. Let me...
With respect to the Entrada, I don't think anybody would debate that both sides had free speech rights. The problem is, increasingly these days, those rights are diametrically opposed to one another, and that one side or the other seeks not historically what was a peaceful demonstration, but a disruptive or preventative protest. My question to the ACLU person, which organization has come a long way from its defense of the city of, in the city of Skokie case. It is retracting itself from what used to be a pure free speech position. There were no guns or weapons, to my knowledge, brought in by the Entrada unless a ceremonial sword came in. My question to you is, as a permitted entity at a public space, was there any set of conditions that would have satisfied you or Dan as to the allowance of the Entrada without disruption or prevention by the protesters? And if so, what conditions would you have urged the city to adopt?
That's a very good question. Typically, in the protest situations where we see these free speech zones used, it is in this way where one group of people is pushed out. The way that the ACLU has talked about from a policy position about free speech zones is when, as it was in Charlottesville, there are multiple groups with clashing views, that would be a situation where, to avoid violence, to avoid the guns winning out, free speech zones where different groups are set up in different places might be necessary. But again, we are always aware of the problem that the further away you are from the heat, the less powerful the message is. And so in this case, I don't see a set of satisfactory policies that the city could have used to create a free speech zone outside of the plaza that wouldn't have interfered with the 8 protesters and the many others who were there protesting their constitutional rights. In this case, we saw again a single protester, counter-protester, who was in favor of the Entrada, who was walking around with a sign right in front of the stage, and where everyone else was being pushed out and pushed away.
So that if the protest was either disrupted or prevented, then you would allow that protest to disrupt or prevent the Entrada?
I think that what you're asking is a difficult question that points to time, place, and manner restrictions that have been traditional restrictions on speech. The gentleman who was speaking about protesters above the legislature, I was glad to hear your comments because you acknowledged that speech can be very disruptive. But part of the power of speech is its disruption, and especially in an event like this that is so hostile to Indigenous people, Native Americans, it's that speech is also very disruptive.
You know, I have not looked at it through that prism just because of the position that we have been in, but I will say as a member of this community, it is my hope that over the coming months that the parties will get together and see if it isn't possible to try to work out an arrangement that everybody feels like they can live with, because as I say, just as a community member, I mean, the Fiesta is supposed to be fun, right? It's supposed to be a place where people can take their children or, you know, people can go to and not have to worry if you know, there's perhaps going to be violence breakout. And so I guess that is something that as a member of this community I'm hoping will happen.
Yeah, picking up on that, I have a vague recollection of after last year's Andrada, I think it was the mayor, said they were going to put together or assemble a group, everybody, to talk about it ahead of time. And I thought, well, that sounded like a great idea, and I'm listening to this discussion, and I have the feeling that that never happened. Do any of you know if that's correct, and if it's correct, why it didn't happen? And this kind of discussion, because it seemed like now would be a good, between now and next Entrada might be a good idea.
So some of the news coverage in this showed that emails that were, you know, IPRA'd showed that there was some discussion about getting some of the Native communities together to have their input, to talk about how maybe the Entrada could not happen or change, or, you know, not be something that was so offensive so that you wouldn't have this protest situation. And I didn't see anything about why it never happened. I know that it was being talked about with city government, and instead what they decided to do was create this free speech zone. I agree with you, Bruce. I think it makes much more sense to bring the groups together and see if they're, you know, because there are two sides here. And I see both of them. I see how the Entrada is a cultural thing. I was actually a Fiesta princess, so I have taken part in the Fiesta things. I also see how it can be very, very offensive, and I think as our city culture changes, things need to change as well, so that accommodations can be made, so that it's not a protest group trying to disrupt something, but it's that, you know, a historical event is evolving so that it includes everyone.
Yeah, and I don't think there was anything that did happen this year, you know, in terms of trying to get folks together to talk this through and see what could be done. I can also tell you that I personally am trying to promote some dialogue to try to make that happen this time around.
We have time for one more.
Let me just fill in one blank, Peter.
Oh, I'm sorry.
As referenced, there were an IPRA and documents were provided. The city government tried to contact the All Indian Pueblo Council, and so it's complicated because it deals with a generational issues that, so maybe the elders were being talked, there was discussions with them, but the younger generation wasn't involved. And I'm pausing because it deals with very complicated tribal issues that I'm not privy to. But those were public documents that were released.
Did we have one more? I thought I didn't see any hand. Did you want to speak? No? Maybe that's all. If that's all, then thank you to our panelists. Our next panel starts right now, so please just stay seated and we'll get on to the 2:30 panel, which is an update on Supreme Court decisions, state and federal. Jack, I think you're going to lead this one up. Where are you, Jack? There you are. The stairs are on that side, so you can go over there.
Yeah, easier to get up that way.
Good job. Thanks again, Zach. Yes. Great. If you just put the computer here, we can plug you in.
You can sit here too, and I'll sit inside.
I take all my directions. I don't do anything without Jack clearing it.
So, Jack, if you'd like to introduce your panelists.
Good afternoon. I'm Jack Hyatt. I'm a member of the Neighborhood Law Center Board of Directors. Our panel today is based on 3 important cases that emanated from New Mexico, and I think you'll find interesting. The bios of our group are in the materials, and I'll skip over that because each of the panelists have said they want more than 15 minutes. I've explained that's not possible, so we're going to hold them to 15 minutes. On my left is Mark Jarmy. On my right, immediate right, is Frank Sussman. On his right is Clinton Mars. And our topics, Mark's going to speak about the Pauley case, which involves qualified immunity for law enforcement officers, in a case that emanated north of here in Glorietta and involved the death of a person. On my right, Frank is going to speak about the case involving the use of public funds for private schools, which went to the U.S. Supreme Court. And lastly, Clinton will talk about an SEC case that went to the U.S. Supreme Court, and he won unanimously, which is pretty amazing in and of itself, I thought. So we'll start with Mark, and Mark, if you would begin and plug in.
All right.
I forgot my watch. Do you have keeping time? Oh, yeah. Okay, Frank, you're next. Oh, no. Sorry, just kidding.
Oh, good enough. I'll leave early. All right. Good afternoon, and thank you for having me. I began my legal career here in Santa Fe as a clerk to Chief Judge Oliver Seth of the 10th Circuit. And it is always a thrill to come back into familiar grounds. Many of you, I do better standing up. Is that okay? Many of you have encountered situations either as lawyers or as citizens in which you... Are they having problems hearing me?
I just want to make sure it gets on. That we're broadcast on TV, so if you could take that mic and make sure it's on. Testing.
All right. I've had an occasion where you've had an encounter with a police officer, which leads you to saying, geez, I wish there was something I could do about that. I think I'll sue. Police officers are many things. I've been representing police officers now for about 25 years in one capacity or another, all around the country. But what they are not frequently is lawyers. And consequently, the law has developed so that while Section 1983 of 42 USC does allow lawsuits to proceed against state and local police officers, there is an ability for police officers to avoid being sued. That's the doctrine of qualified immunity. And because police officers are not lawyers, qualified immunity asks two fairly simple questions. First, was a constitutional right violated? And second, was the law sufficiently clearly established such that every reasonable police officer would know that he or she was violating the law? A prong one. Police officer encounters the citizen on the street and says, "Hi, I'm Officer Smith. What's your name?" Is a constitutional right violated? I think we can all probably agree as lawyers, no, it's not. And so that would be a prong one sort of situation. No constitutional right is violated. The far more difficult cases come in those areas where a police officer has to use force. And then the question is asked, was the law sufficiently clearly established that the police officer knew he was doing wrong? There are a couple of questions that the courts used to look at. The first is, can the court identify a specific constitutional right at issue in a given case? And after doing so, the court still has to determine the elements of and the rules associated with the action seeking damages for its violation. What's important to recognize is that in 42 USC 1983 litigation, we'll just call it 1983 litigation, qualified immunity protects the police officers. The deck is stacked against plaintiffs in this case. Qualified immunity is going to protect all but the plainly incompetent or those who knowingly violate the law. And it's sometimes difficult, and we know this from our life experience, for an officer to determine how the relevant legal doctrine, in most cases excessive force, will apply to the factual situation which the officer has. So the plaintiff has the burden, not the defendant, of showing that qualified immunity is not applicable. And the courts have called this a demanding standard. So, what a case that I took to the United States Supreme Court this year holds, and I'll give you the holding first and then we'll go into the facts of the case. For a law to be clearly established, existing precedent must have placed the statutory or constitutional question beyond debate. How do you have something that is beyond debate? Well, the court has suggested in Pauley versus White that unless the lower courts can identify a case where an officer was acting under similar circumstances, there is a violation of the Fourth Amendment. In Glorieta, New Mexico, and I adapted this from a presentation I did in California. Most of them don't know where New Mexico is, much less where Glorieta is. There was an incident of road rage. Samuel and Pauley and his brother Daniel lived in Glorieta in a small house behind the main house. They were both waiters at a local restaurant. and both in their early 20s, pardon me, mid-20s. Daniel got involved in a road rage incident with a couple of young women from Las Vegas, and they ended up calling the state police. State police responded and talked to the girls, and eventually found the location of the Pauley brothers' home. And this our resolution here is not great, and I apologize for that. But we're going to be talking about this area up in here, and I'll have better photographs of it for you in a second. There is a officers proceeded. It's about, I'm going to say, 10 o'clock at night, 10:30 at night, up to the home. It is a dark night, and as you know from living up here, Glorieta is not a well-lit metropolis. The officers are fearful because the young women have described a situation in which they felt in fear for their own lives. Police officers not wanting the driver of the car to get back onto the road decide to approach the house with some caution and intermittently flash their lights as they're going up the hill towards the home. As the officers approach the home, they decide not to knock on the front door, but rather they would rather have people come out to talk to them. And so they call out, state police, come out and talk to us. There are two officers. Both are behind this rock wall that's about 3.5 feet tall, and one is out back. The brothers, who have had both marijuana and alcohol, are non-responsive. And then finally, one of them calls out, "We've got guns." State police then take cover, and then almost simultaneously to this calling of "We've got guns," one of the brothers, and we believe it to have been Daniel, fires 2 shotgun blasts out the back of the house. Here's where our rock wall is. I have a police officer right back here. Daniel fires 2 blasts out there, and the officers in the front of the house believe that their companion may be in mortal danger. At the same time that Daniel goes to the back of the house, his brother Samuel comes to the front of the house. This is what the officers perceive. This is a nighttime shot, and they see Samuel Pauley here come to this picture window. He is backlit, and it is undisputed that he points a gun directly at Officer White of the New Mexico State Police. The sequence then goes as follows. 2 shotgun blasts, bang, bang, very loudly in the back of the house. A 3rd shot, which we contend, but the court could not accept for purposes of its legal analysis, was fired directly by Samuel, and then a single shot from Ray White immediately thereafter, which pierced Samuel Pauley through the heart and killed him. This is the view of the officer, of the decedent out towards the rock wall, which is here. The question is, what happens? Well, a lawsuit is obviously brought by the brothers, Samuel's estate and Daniel, alleging that they violated Samuel's 4th Amendment right to be free from excessive force. There's no other 4th or 14th Amendment violations that are claimed, and the officers assert qualified immunity. I assert it on their behalf. And say, hey, it's just not clear in these circumstances what a reasonable officer should have done. Judge Ken Gonzalez denied my motion for qualified immunity. I took it up to the 10th Circuit, which split 2-1 against me, with vigorous dissent by Judge Moritz. Those of you who are lawyers know that that is an open invitation to seek en banc review, a review of the entire 10th Circuit. And I did. And the court split 6-6. With Judge Hartz of this state saying, you know, it'd be helpful if the Supreme Court clarified the law. I can take a hint. A 6-6 panel en banc decision upholds the panel decision, and so at this point I've still lost. There is then a series of briefing that happens, and I think I finally get a chance for the first time in almost 40 years of practicing law to actually argue a case to the United States Supreme Court. I'm thinking, how cool is this going to be? I know this is a possibility because I'm getting calls from law firms all around the country saying, don't worry your pretty little head about this, Mark. We'll take care of the oral argument for you. And I thought, you'll pry this out of my hands the day that I die. It's just not going to happen. Unfortunately, I didn't get that chance because the Supreme Court came back and with an 8-0 verdict in my favor, reversed the denial of qualified immunity. We went back to Denver, and the original panel then voted 3-0 to dismiss the qualified immunity claims. So, let me tell you a little bit about the law as to why this all occurred. The 10th Circuit was unable to identify a case where the officer acting under similar circumstances, such as Officer White, could have violated the Fourth Amendment. Instead, they looked at too general an area of law and decided that no, we just can't, the law has to be specific so the officers will understand it. This case, the court held, presented a unique set of facts and circumstances. There are a number of legal points that I would refer you to the 8-page per curiam opinion that came down about this. But here is what you need to know if you're practicing in this area. The deck is now far more firmly stashed in favor of police officers. This was a sea change in the law of qualified immunity in which police officers now can almost uniformly say, hey, this was a unique set of circumstances and I didn't know how the law applied to it, and consequently be able to successfully assert qualified immunity. As practitioners, you will know both ways to support or to rebut that in your taking of discovery. But here's what you need to know. A court can uphold the denial of qualified immunity only if the plaintiff meets the burden of showing an actual constitutional violation and finding particularized, clearly established law that squarely governs the case at hand. This burden is all the more heavy following the Supreme Court's decision in White versus Pauley. What I can tell you is this. For police officers, the law is now much more clear that they can act reasonably, and if there's nothing that is legally to the contrary, they are likely going to be immune from suit. This is a case I can tell you that has been cited well over 100 times in the 10 months since it has come out. It is a case which protects the ability of police officers to do what they need to do in order to defend themselves and to be consequently immune from suit. I think I'm coming close to 15 minutes.
You can take one more minute if you'd like.
One more minute, I'll take it. Sorry. If you are practicing as a plaintiff's lawyer, you will need to establish that, and before you even accept a case, I would look very closely, is there anything that looks like this in the law? If it's not, I would suggest that you look hard at White versus Pauley and maybe take a pass on the case. If you are a defense lawyer, this case, White versus Pauley, is your new best friend. You may assert this, and we have had several times since White versus Pauley qualified immunity granted on this basis. That is, that the law was not clearly established. I think there's going to be some time for questions at the end.
Yes.
Okay, I'll go ahead and yield back the remainder of my time, as they say in DC.
Thank you, Mark. So, Frank, would you take the microphone, please? Thank you.
Let me start with a caveat, and that is that I am not licensed to practice law in the state of New Mexico.
Oh, well, we're going.
Nor am I licensed in 16 of the 17 other states in which I've had occasion to litigate. But I've been asked to talk about a case that is now pending in round 2 in the New Mexico Supreme Court, which hopefully will not be a 15-round fight by the time it is over for good. I had lived in New Mexico for about 6 years before I became aware that New Mexico law required the Department of Education to loan textbooks and other instructional materials to all public and non-public schools, including sectarian schools. And having successfully argued an identical case before the Missouri Supreme Court in 1974, some 38 years prior, my spider sense started to tingle. And I quickly learned that New Mexico would also require local and licensed co-counsel, and since I did not know any local lawyers at that time, I started to ask around. And after proposing my promise to 5 other recommended attorneys, that if they accepted the role of acting as co-counsel, I would personally bear all out-of-pocket expenses, and they would never have to speak a single word in court or write a single sentence of pleadings or of briefs, they say, nevertheless, all respectfully declined. At some point, someone recommended Chris Grazier to me, a true warrior for truth and justice, and I met with Chris, made him the same spectacular offer, and he readily accepted, knowing a good deal when he saw it. My next hurdle was to be admitted pro hoc vice by the New Mexico Bar Association. I filled out an application noting in the event of success, there was no possibility of a fee award, and the matter would be handled strictly on a pro bono basis, and the Bar Association granted my application and graciously waived the normal fee, although somewhat exorbitant, that would have been involved. After much searching, I located 2 plaintiffs, my only requirements being that they were New Mexico residents and they had 1 or more children in the public school system. The plaintiffs are Kate Moses, a local Santa Fe artist, and Paul Weinbaum, who lives in Las Cruces, who is and has always been a strong church-state advocate, whom I had located through the internet, and who had once unsuccessfully sued to have the crosses removed from the Las Cruces city seal. The lawsuit was filed in January of 2012, almost 6 years ago. At the first scheduled conference before Judge Singleton, she announced from the bench, much to everyone's surprise, that she'd be ruling in plaintiff's favor, a decision which proved to be too good to be true. Summary judgment motions were subsequently filed by all parties. Sutton, Thayer, and Brown entered their appearance for the New Mexico Department of Education, and Moldahl, Sperling, Roll, Harris, and Sisk, and the Beckett Fund for Religious Liberty out of Washington, D.C., entered their representation for the interveners, individual non-public schools, and for the New Mexico Association of Non-Public Schools. I was confident that the defendants' counsel's confidence in overwhelming me by sheer numbers and resources would be greatly diminished once they learned that I had Chris Grazier, one of your hosts today, on my side. In October of 2014, almost 3 years after the case was filed, Judge Singleton granted summary judgment to the defendants. Plaintiffs promptly appealed, and 1 year later, in October of 2015, the Court of Appeals unanimously affirmed the district court. At the time of the appellate argument, I knew it had not gone well. Plaintiffs timely filed a petition for cert, which was granted by our Supreme Court in January of 2015. And in November of 2015, the Supreme Court unanimously reversed the trial court and the appellate court's opinions and held the Challenge Act to be violated violative of Article 12, Section 3 of the New Mexico Constitution. This initial opinion of the Supreme Court, for reasons unbeknownst to anyone, was later withdrawn and with very minor changes reissued on February 10th of 2016. At the time of the oral argument in the New Mexico Supreme Court, I felt confident that the plaintiffs would prevail. In addition to Article 12, Section 3, plaintiffs had raised constitutional challenges to the Act under Article 11, Article 2, Section 11, Article 4, Section 31, and Article 9, Section 14 as well. But there's a sort of an established principle that if the court finds a case to be unconstitutional under one section, you don't bother to address others. And that's what happened in this case. Subsequent to the remand, the Beckett Fund filed a writ of cert. Exactly whose religious liberty they stand for, I've never quite been able to figure out. But they filed a writ of certiorari to the U.S. Supreme Court, which was granted, returning this case back to the New Mexico Supreme Court for reconsideration in light of a case decided last term by the U.S. Supreme Court, Trinity Lutheran Church of Columbia, Inc. versus Comer. Subsequent to the remand by the U.S. Supreme Court and pursuant to motions filed by plaintiffs, the New Mexico Supreme Court has ordered further simultaneous briefing by the parties, with initial briefs now having been filed on November 13th this year and responsive briefs due to be filed on December 18th, with oral argument to be scheduled following the filing of all briefs. Not only do I believe that Trinity Lutheran has no bearing whatsoever on the Moses case, I believe the Challenge Act unquestionably violates Article 431 and Article 9, Section 14, previously unaddressed by our Supreme Court in its prior opinion. The re-argument of Moses will be a new, though unwelcome experience, inasmuch as it will be to me, to the best of my knowledge, before the only state Supreme Court on which female justices outnumber male justices. To give you a flavor of what the constitutional provisions are, not expecting you to know them, Article 12, Section 3, which is the article and section that the Supreme Court originally relied on here, says no part of any funds appropriated, levied, or collected for educational purposes shall be used for the support of any sectarian, denominational, or private school. So even if the language which the defendants now claim is offensive, the sectarian and denominational, they are still private schools and would be covered by this section. And this is a section that our Supreme Court relied on. The additional two sections which are involved, Article 4, Section 3 says, and this is all very clear, plain language, forbids any appropriation for educational purposes to any person, corporation, association, institution, not under the absolute control of the state. Not very confusing. And Article 9, Section 14 says, which is normally known as the anti-donation clause, probably a familiar phrase to most of you, that neither the state nor any county or school district shall directly or indirectly make any donation to or in aid of any person, association, or public or private corporation. It's hard to imagine how any court could possibly say that the Challenge Act here, the textbook lending statute, passes any one of those. And I would predict that in the near future, we're going to see a great expansion of rights and liberties being claimed, and perhaps granted to religious organizations. As you probably know, the proposed congressional tax bill permits political activity by tax-exempt religious institutions, which they're presently prohibited from doing. So you're going to be hearing sermons from the pulpit endorsing candidates. And one of the arguments that the plaintiffs have raised in this case, that if textbooks and other instructional materials can be loaned by the state, there's no reason they're not going to be asked to loan buses and buildings and teachers and a myriad of other financial obligations that they have presently. I also believe that the Supreme Court will not change its original opinion, our Supreme Court, as opposed to Washington. And that much of what the Supreme Court in Moses has said, and will repeat, also applies to charter schools. I firmly believe that charter schools in this state are unconstitutional under our constitutional provisions. There's been only one other state Supreme Court that has ruled on charter schools, and that was the state of Washington 2 or 3 years ago, under the state of Washington's constitution, which in this regard is not that much different. And they held that charter schools in the state of Washington were unconstitutional for two primary reasons. One, that public funds were involved, and secondly, and more importantly, that the public has no input into the local school boards of charter schools. Charter schools appoint their own boards. They can fire them at will, and they do, and appoint their friends and relatives to the new board. This recent case,
Go ahead. No, you've got time. Go ahead.
This recent case that was argued just a few days ago, which you probably read about in the paper, called Masterpiece Cake Shop versus Colorado Civil Rights Commission, argued actually on the 5th of this month, threatens all federal and local Civil Rights Act. Potentially, if a bakery can refuse to make a wedding cake for a gay couple, any public business could refuse to have African Americans as customers on the perceived belief that they are, quote, mud people, frequently referred to in the Bible, because no court is going to examine whether a religious belief is sincere or not. And as has been the situation in the past, this will be my final comments. The Supreme Court has otherwise been evenly divided in major cases. The key vote, and even in Masterpiece Cake Shop, is going to be Justice Kennedy. And I would remind you that Justice Kennedy was the author of the two opinions holding that sodomy statutes outlawing gay sex were unconstitutional, and also was the author of the Supreme Court's opinion legitimizing gay marriage. So there's some hope that the Supreme Court will vote 5-4 that if you have a public business, even if you have a sincere religious belief, it doesn't permit you to discriminate.
Clinton?
Thank you, Jack. I know it's getting towards the end of the day, and by now I'm assuming that everybody's booked their annual budget for CLE credits. Congratulations on that. I was happy to be asked to come here because I needed to fulfill my requirements. I'm short 6/10 of a credit, and I think I've already satisfied that. My case, I represented Charlie Kokesh, so there was a Santa Fe nexus with my case. Some of you may remember him from the days when he was a somewhat notorious member of the business and social community of Santa Fe. The case is the Securities and Exchange Commission versus Kokesh. That's a civil enforcement proceeding. You don't see a lot of those, even on a good day. You just don't see a lot of those kind of cases in New Mexico. For obvious reasons, New Mexico is a capital poor state. It's really not the mecca of corporate transactions, large-scale corporate fraud, the kind of things that the SEC looks at. You don't have a lot of that, thankfully, in New Mexico, regretfully, for the reason that we are a poor state. So, you know, why did this case arise here? Well, Charlie Kokesh had his business empire based out of California, and he relocated at the height of his success, you know, moved to Santa Fe to be part of the Santa Fe lifestyle. Just very briefly, and let me say this, normally you might think, you know, what does an SEC civil enforcement case have to do with the interests, what I presume are the main interests of this crowd? It has to do with the statute, 28 U.S.C. 2462. That's a penalty, a civil penalty statute. That civil penalty statute is not by its terms, limited to SEC enforcement cases. It would imply that that statute applies to FERC penalties, federal energy regulatory penalties, environmental penalties, you know, a wide range of federal civil penalties are governed by that statute. So for that reason, this case, even though nominally, you know, you think, well, it's an SEC case, what does it have to do with me? This case might be of some interest to you if you're involved in federal regulatory matters where the enforcers are threatening your clients with, you know, extravagant penalties. Now, in this particular case, the remedy, the relief that was heavily contested was, you know, what was formerly known as the, you know, equitable remedy of disgorgement. Now, with SEC versus Kokesh, what the Supreme Court held was that when the remedy that's styled that the government casts as a claim invoking the court's equitable power to fashion a remedy of disgorgement, if what's really going on is the money, the disgorgement amount, if that's being imposed as a sanction for the violation of a public statute, you know, federal regulatory statutes, in this case the federal securities laws, then even though it's called disgorgement of ill-gotten gains, even though the court invokes its equitable powers, what it's doing as a practical matter and now as a legal matter is imposing a sanction in the form of a penalty. And in this case, a monetary penalty, and by the language of 28 U.S.C. 2462, that statute does not apply to monetary penalties. Now, let me just slow it down for a bit and just talk about that statute, 28 U.S.C. Section 2462. It's essentially a statute of limitations. And when the case came to me, you know, I do big part of my practice is federal securities litigation, stockbroker and investment advisor malpractice cases, you know, disputes in the industry, in the securities industry. So Charlie Kokesh comes to me in 2009. He's just been served with the SEC's civil complaint. And what the government is suing him for is you know, allegations that he controlled two companies, two SEC-registered investment advisory firms. And these two firms had investment advisory contracts with a series of other companies called business development corporations, BDCs. And under the federal securities law at the time, somebody could put together a BDC, the Business Development Corporation, and it was sort of a venture capital, kind of an entrepreneurial thing. You would go out and sell stock to the public, use the proceeds of those sales as capital to develop some product. In this case, most of these BDCs focused on medical technology. And there are favorable, tax favorable rules that govern that capital formation. The security offering rules are relaxed, to favor capital formation. But in exchange for those benefits, there are restrictions on what the BDCs can do with that money, including restrictions on the kinds of money that the BDCs can pay to an investment advisor. So remember, Charlie's registered investment advisory firms, by contract, were managing the money, the investments for the BDCs, and under the rules, the BDCs were not allowed to compensate the registered advisory firms by means of paying the RIA's rent, overhead, things of that nature. Can't reimburse for salaries, can't reimburse for bonuses, things of that nature. And so what the government alleged is through the vehicle of these RIAs that Charlie Kokesh controlled, he was causing the BDCs to flow money out to the RIAs in the form of rent and reimbursement and other illegal and improper payments. And of course, Mr. Kokesh then, he owned, I forget if it was 80 or 90% of the RIAs, and they would just turn around and distribute that money to him individually. So that's sort of the gist of the government's claims. And in 2009, late 2009, when the government sued Mr. Kokesh, they extended the reach of their claims all the way back to 1995. And so, you know, you don't have to have much experience in the legal world to, you know, instantly think, well, there must be a statute of limitations problem with that. And so we looked at 28 USC section 2462, which imposes a 5-year statute of limitations. And by the way, this is why this may have implications for other areas of regulatory law. It imposes this 5-year statute of limitations on penalty claims. But here's the important point. When the penalty claim is not separately anchored by its own statutory authority. So that sort of sounds like, well, what does that mean? If you cheat on your taxes and the IRS catches you in an audit, they are going to come after you for the taxes, but they're also going to impose tax penalties. And the tax penalties can be draconian. Well, tax penalties have their own separate statutory authority. You can go to Title 26 to the Internal Revenue Code, and there are specific statutes prescribing particular penalties. Well, in the area of securities regulation, Title 15, believe it or not, strangely enough, after all these decades, there are no specifically statutorily sourced penalties other than a civil monetary penalty that was prescribed, you know, late in the day, back in, I think maybe in the 1990s. But generally, the government would get around the absence of statutory penalties by making these equitable disgorgement claims. So, and because because Section 2462 applied to penalties and not equitable remedies, the government argued, therefore, the 5-year statute of limitations doesn't apply, and there is no other general residual federal statute of limitations, therefore, no time bar. That's the government's theory, and they've been traveling on that since the 70s. And you know, we went back and looked at the fiscal data on the SEC website. You could probably do the same thing for the Department of Energy, any other federal agency. They have data on their websites. And you can track over time how much they're collecting in statutory-based civil monetary penalties versus how much they're collecting over time through equitable disgorgement claims. And in the case of the SEC, you had, you know, very modest growth across the decades in civil monetary penalties, which are anchored to a statute, but then you had the rate of increase in the collection of equitable disgorgement amounts going through the roof to the point where up until this case put a stop to it, the feds were collecting billions of dollars a year in SEC civil penalties, or disgorgement amounts, I'm sorry. So that was sort of what was an issue behind the seemingly parochial case of SEC versus Kokesh. And for me, it had some, you know, sort of some interest because I knew about the Santa Fe history and all that. I was interested in the statute of limitations argument. And there was another issue that the statute suggested. The statutory language is you know, the courts sort of virtually universally treat this statute as a statute of limitations. Now, a typical statute of limitations will say that a court, that a plaintiff can't maintain a claim unless it's timely filed. It's the sort of the grammatical force of the language is it's pointing the finger at the plaintiff, and it says you can't do something, you can't maintain something if you don't assert it in time. Well, this particular statute, which is nearly universally regarded as a statute of limitations, does not read that way. Just the syntax points the finger at the federal court. At least this is my view, the argument I made. The force of the mandate is directed toward the district court, because what this statute says is that an action shall not be maintained. It says to the district court, you shall not maintain an action that asserts an untimely claim. And if you go back and look for the past 100 years, you find lots of case law at all levels of the federal system that sort of the imperious statement, thou shalt not maintain an action when it's directed to a federal district court, that's a subject matter jurisdictional limitation. And it's Congress telling the federal district court that you do not have the power or the authority to entertain the action, and so all you can do is dismiss the action. And then it goes on to say, to put a sort of definition on what kind of actions. It's an action for one of these penalties that I've been talking about. And then it has a further limitation. It says when the action asserts a claim that first accrued more than 5 years ago. It doesn't say a claim that accrued more than 5 years ago. It says first accrued. Well, in the securities area, one of the claims against Mr. Kokesh was that he published false 10Ks or caused false Form 10Ks and 10Qs to be filed by the BDCs, that he aided and abetted that violation. And that he caused those false representations to be repeated annually every year, because you have to file a 10K. Corporations, public corporations, have to file 10Ks annually, have to file 10Qs quarterly, and that continuing filing extended into the 5-year period. So my argument was, well, that's fine, but the statute says first accrued, and it first accrued back in the year 2000, which is more than 5 years before you brought the suit. So Judge, you don't have jurisdiction over this. This statute tells you that you can't maintain it. Coming from New Mexico, no court's ever held that. The issue really had never been presented, no reported decisions. And we're cooking along, and then all of a sudden, kind of out of the blue, this crusty old federal district judge in the Middle District of Florida, Judge King, came out with a reported decision. And lo and behold, he accepted the argument I was making, although it wasn't my argument. I'm not the lawyer in the case, but just coincidentally, some lawyer in Florida is making the same argument. So it's a first instance of just a stroke of luck, just wild luck. Who would thunk, And so I pull that forward and milk it for all it's worth. And the court in Albuquerque at one point debunked that case, sort of made a comment about how, well, that judge, I know something about that federal district judge, and he's somewhat of an outlier, so I'm not going to give a lot of weight to that case. But it just indicated the extreme skepticism that I was facing in the trial court. Meanwhile, the SEC's having kind of a Madoff fraud backlash. So the SEC's real sensitive about appearing soft. The settlement negotiations were very volatile. We almost settled the case, and then in Washington, the director of enforcement for the SEC was this guy Andrew Serezny, and he was the last guy that had to accept the terms of settlement before it would go to the 5-member commission, and then they would vote on it. But he says, and I'll never forget his words were, you know, this settlement makes sense, but the optics are intolerable. And so, you know, I can't accept this. It really is a political decision. And so that was the end of that. We went back to district court, and we were battling out with motion practice. And, you know, the second stroke of luck hits. And just out of the blue, the Supreme Court, the federal Supreme Court, in a case SEC versus Gabelli, decides a case. Very simple opinion. And they hold, for the first time, they hold that this statute that we're fighting over in the Kokesh case, that it indeed applies to civil monetary penalties in SEC enforcement cases. Now that in and of itself was not that surprising. It's so you can like, well, everybody thinks that, but the Supreme Court's never really said it. You know, so for the first time they say it. And then they add that the discovery rule that you have in fraud cases, that the discovery rule does not apply in SEC cases. So the discovery rule will not, the SEC can't use the discovery rule to try to toll the statute of limitations. So that was interesting. And it sort of, you know, stimulated the urgency of our cross motions for summary judgment, battled that out. It sort of led to a renewed interest in settlement. But, you know, other dynamics intervened, which I can't go into, and those settlement ventures failed. Next thing you know, we had a trial, a jury trial in Las Cruces. You know, it was a tough case. One of the witnesses against Mr. Kokesh was the family pastor. That did not help. The jury found liability on most of the counts. The district court judge threw one count out. Long and short, by the time the dust settled, the principal amount of damages were $35 million. The prejudgment interest, going all the way back to 1995, it was around $20 million. So all of a sudden, Mr. Kokesh is looking at, you know, $55 million and counting. Up to the 10th Circuit, and it went to the 10th Circuit on these two issues: the 11th commandment to the federal district judge that thou shalt not entertain this action if, and the disgorgement issue. Judge Hartz was the head of the panel. We had a very lively discussion about the 11th commandment argument. And the 10th Circuit basically avoided that issue, finding that it didn't matter because in any event, the disgorgement amount was not a penalty, and because of the annual publication of these false 10Ks, the last one extended into the 5-year period, that there was timeliness. And at that point, you know, having had the first luck with Judge King's district court decision in the Middle District of Florida, and then the Gabelli decision by the Supreme Court, well, wouldn't you know it, during the after our case was fully briefed in the 10th Circuit and we're waiting for a decision, lo and behold, the 11th Circuit rules in King's case, holding, you know, rejecting the thou shalt not entertain argument, but holding that disgorgement is a penalty for purposes of the statute in civil enforcement actions. You know, we gave notice of supplemental authority to the 10th Circuit. 10th Circuit comes out and they hold that the disgorgement is not a penalty. So now you have a circuit split between the 10th and the 11th Circuits. You know, apply for a writ to the Supreme Court. They take it, even though the circuit split's pretty new, but it's the SEC. Billions a year are at stake. And in response to the writ application, the SEC stepped forward and said, we agree you should take this case up. Now you figure they must have thought that this was a good vehicle, you know, for the matter to be decided. Okay, I'll wrap it up. So we go to the Supreme Court, 9-0. They get to have the last word on it. So even though, you know, legions of courts over the decades had held that disgorgement amounts are not penalties, in the unanimous opinion, Justice Sotomayor, in one little sentence says, more or less says, you know, and I'm exaggerating somewhat, but, you know, if only all cases were this easy to decide. And it's like, well, tell that to the decades of struggling lawyers who have lost this argument in, you know, virtually every federal district court and court of appeal in the land. And now here we are in my case, and she thinks it's the easiest case in the world. I agree, it should have been decided in our favor a long time ago. In closing, let me just say this. It's seemingly an SEC case, as I said, but if any of you are out there looking at other federal penalties that are not separately anchored to their own statute, then this residual statute 2462 might be something you want to look at. In a footnote in Kokesh, footnote 3, take a look at that. The court, remember this is the unanimous court, says, look, you know, we're not saying that a federal district court can impose a penalty amount under the heading of equitable powers. You know, the implication being, if a court's imposing a penalty amount and that penalty does not have a separate standalone federal statutory anchor, then the federal court might not have the power to do that. And so you might want to look at that. The last thing, let me just say really quickly, so now there's a class action suit. Some enterprising lawyer filed a class action suit to try to recover the billions that the Supreme Court has collected over the years under this doctrine of disgorgement that the Supreme Court now says they never had the authority to give in the first place. So we'll see where that goes. Thank you very much.
Do we have questions? We have time for a few. Brian?
So I'm going to use a famous Zach Chandler disclaimer. I'm asking this question as my capacity as a private lawyer on behalf of myself only. With regard to qualified immunity, it strikes me, and this is not just within the law enforcement context, but that anywhere that qualified immunity applies, our firm had a case against a state actor, a foster parent, who claimed qualified immunity, and the same logic was applied in that case, where there was not a clearly established precedent in the 10th Circuit. In our case, they would put the foster parent on notice that raping a child was not clearly violative of the child's rights, and qualified immunity was applied in that case. It seems to me that the way the Supreme Court has set it up is that the law is frozen from this point forward. Because I feel to see just as a matter of logic, if there isn't at this moment a case reported with facts similar to the next instance, there never will be. And so maybe I'm seeing it wrong, but I guess I just don't quite understand the idea of how the facts that are applied to any of the state actors claiming qualified immunity, that law isn't frozen in place. Like, how do you meet the standard? If you have a new fact pattern, how do you show that there is a reported case or a clearly established precedent that those facts make it undeniably certain that qualified immunity applies?
You made an excellent point, Mr. Speaker. I will tell you that I think it is extremely difficult for plaintiffs' lawyers to bring new 1983 actions under a unique theory of law. I think that without something that you can point to and say, and here you said it was wrong too, trying to bring a unique theory of law is likely to be unsuccessful after White versus Pauley.
Okay, I think we have time for one more question, but this will be the last.
Well, let me just respond, Brian. So in White versus Pauley, after the Supreme Court did what it did, it went back to the 10th Circuit. And the 10th Circuit went through the facts and found that Officer White, in fact, violated the dead person's constitutional rights. And then it said, but under the Supreme Court's ruling, we had to have found there was a case, so he gets qualified immunity. That means from now on, anybody who did what White did no longer has the cloak of qualified immunity. Now, because the court has said that was unconstitutional, the fact that they went ahead and granted qualified immunity to him doesn't mean that he didn't act unconstitutionally. Every police officer in the world, where the 10th Circuit is on notice now. The problem is that for a while, the Supreme Court's jurisprudence was that the court should go, because of the problem you raised, the court should go ahead and decide constitutionality and then qualified immunity. And then recognizing, in my view, recognizing that they had set in motion the possibility for a progression of the law, they went ahead and said, well, actually, you can just decide the immunity without deciding the constitutionality. But sometimes the courts will decide the constitutional question. And in fact, the 10th Circuit did here on facts somewhat different than the ones Mr. Jarmy cited here. And they went through and recited all of those and said he violated their rights. So there's some possibility, but there's no doubt that the qualified immunity doctrine makes it really hard to bring novel questions of constitutional law.
Thank you.
Thank you to our panelists. And we have a 15-minute break now, so go ahead and take your time. We're coming up on our ethics segment. Is our very last segment of the program. I'll take this opportunity to remind you, please do fill out your CLE forms, please do sign them, and please do fill out an evaluation form before you leave.
It's probably better go this way where there's a snare.
Let me just see how to do this.
Okay, if people can sit down, we're ready to do our last panel of the day, which is one of your ethics and professionalism credits. So I'm sure many of you are eager to get this in before the end of the year. We will try and stay right on schedule so you can all go home. I know it's the weekend. And by way of introduction, I'll just say that Paul, in my estimation, is one of the most informed people in New Mexico on ethical issues. He's worked on multiple ethical issues in different contexts, both legislative and otherwise, and he's presented it to this group for several years, so he shouldn't be new to a lot of you that are repeat attendees. And today he's got some interesting updates where things are happening in the world of ethics in New Mexico, and some of the changes are quite remarkable. So with that, I'll turn it over to you, Paul.
Thank you very much, Peter, and thanks for inviting me back. So what I thought I'd look at today for a change from previous years, and so as to hopefully keep it interesting for all of us, including me, was to look at the last year and see what has developed in ethics law in the year 2017. And answer this question, will 2017 go down as a breakthrough year for public and campaign ethics? And I think that's certainly a plausible possibility. I wouldn't say that the jury's out yet, but I think that, pardon, the jury's back yet, but I do think that there is a substantial possibility that both statewide and here in Santa Fe, we are going to see some breakthroughs, or we'll look back on 2017 as a year that constituted breakthroughs. And I'm going to be looking at several sources, the Constitution, and then statutes where there's been changes, regulations, and the courts. And for those of you who are either millennials or Generation Z, in the upper right corner, those brown books, they're called statute books. It's the way we old-timers used to look at the law and find it. It's just museums now, you know. So how did 2017 begin? Well, first of all, New Mexico remained, as it still does, one of 8 states with no ethics commission. Our ethics, or I should say no state ethics commission, no statewide one. Ethics enforcement was and remains scattered for agencies, for the executive branch, and for the legislative branch for that matter, among administrative agencies and various prosecution authorities. And I think the one exception is the courts. That is centralized through the Supreme Court and the Judicial Standards Commission. But apart from that, pretty much everything is scattered among different agencies and has been for many years. The various statutes that we've talked about in previous years, such as the Governmental Conduct Act, which is the flagship statute, but also the ethics provisions in criminal law, the procurement code, ethics provisions, all of those remain scattered among different agencies in terms of their interpretation and enforcement. Secondly, 2017 began in a position where contributions to independent campaign organizations were neither limited nor subject to disclosure under statute. Santa Fe's ordinance, for those of us living in Santa Fe and voting or concerned about Santa Fe's elections, did by that time require disclosure. That had been done by the City Council at the request of the Ethics and Campaign Review Board. But contributions otherwise to independent campaign organizations were not required to disclosure. Now, they're never limited because that's considered by the Citizens United decision of the Supreme Court to be sacrosanct. It's First Amendment, it's free speech, so you can't require people who contribute to an independent organization to subject themselves to any limits. But you can require their disclosure, and we just haven't done it on a statewide level. And at the beginning of 2017, Senator Phil Griego was facing felony charges for ethical violations as a senator. And let me just preface this by saying I hold no personal animus towards Senator Griego. He's actually been very kind to me. This is just a matter of something for educational purposes, not that I do with any enthusiasm when I talk about that case. So where do these public ethics issues stand as this year ends? Well, there has been progress. The State Ethics Commission, for the first time, and I went back through the legislative index and looked up State Ethics Commission, and found the first bill that I could find was introduced in 2007. My sense tells me that's not right, that it was actually even earlier than that. But for at least 10 years, we have not had any legislation pass or at least be signed into law by the governor, including the past governor, not just the current one, on an ethics commission. Well, in 2017, this year's legislative session, we finally did get a constitutional amendment or a joint resolution that puts a constitutional amendment on the ballot for the next election, November 2018. Secondly, Campaign Reporting Act amendments were passed by the legislature, but vetoed. And I'll talk about that. But then there were Secretary of State campaign disclosure rules that were adopted and are in effect. And the city of Santa Fe had the opportunity to actually enforce and interpret its campaign reporting requirements ordinance. And finally, Senator Griego, as I'm sure we all know, was convicted on 5 counts and is awaiting sentencing in February. So let me start by talking about what I think is probably the most comprehensive of those issues, the State Ethics Commission constitutional amendment, which is going to be on the ballot. The State Ethics Commission is closer than ever. If the voters approve it in the November election, then they would basically compel the state legislature and the governor to adopt legislation. It just would not be possible for them not to adopt some kind of legislation to enable the constitutional amendment to be effectuated and to appropriate funds. How much and what kinds of authority, that's a little different, but at least we know they have to do something. What does the constitutional amendment provide if it is adopted by the voters next November? Well, it would set up a 7-member ethics commission. 1 member appointed by the governor, 4 appointed by legislative leaders, both the majority and minority leaders. Well, actually, it's it's not the majority leader, it's the president pro tem of the Senate and the minority leader of the Senate, and the speaker and the minority leader of the House in the 2 parties. Those 4 legislative appointees would then appoint 2 more members for a total of 7. No more than 3 commissioners would be allowed to be appointed from the same political party. 2 of them, the 2 that were chosen by the legislative appointees, could not be from the same party. That doesn't quite say they have to be a Democrat and a Republican. We have a lot of independents in this state, as long as no 2 of them are either Democrats or Republicans or Greens or whatever. Terms and qualifications are otherwise as provided by law. What would the constitutional amendment provide in terms of authority of the commission? Well, it would provide that it would give the commission independent authority over state officers and employees of the executive and legislative branches of government. This is a constitutional body that would not report to anybody else, just like the Public Regulation Commission doesn't report to the governor. They may get appointed by the governor. They don't report to the governor. They're not responsible to the governor. Once they're appointed, they're in office, and that's exactly what this would set up. Candidates or other participants in elections would be subject to the independent authority of this new body. I take it probably that when they say other participants in elections, they're probably not talking about voters. You know, I mean, it just seems like that's going a little far with those words. So I assume they're talking about people who are not just the candidates, but also their staff, and I assume, and people who are engaged in some way. But it's pretty wide open at this point what that would mean. Lobbyists would be subject to the authority of the commission, government contractors or those who seek government contracts, and otherwise as provided by law. What would the amendment provide regarding the actual nature of this authority? Well, or what issues, I should say, would they have authority over? Well, they would have authority over the standards of ethical conduct, other standards of conduct, reporting requirements, and as may be provided by law. You notice there's a continuing theme here? The commission would be empowered to initiate, receive, investigate, and adjudicate complaints alleging violations of the laws that are subject to their authority, issue advisory opinions, exercise subpoena powers over witnesses and documents as may be provided by law. And it will have such other powers and duties and administer or enforce such other acts as further provided by law. Those words, provided by law, appear 5 times in this constitutional amendment. It's 2 pages long, it's 2 substantive sections, and 5 times as further provided by law. And what's that about? Well, what happened was the original version of the constitutional amendment was 7 pages long. It had a lot of provisions. It covered a lot of these issues. And one by one, as we went through committee, we found that, I was working at the legislature, we found that they couldn't quite get agreement. So they would just say, well, let's just say as provided by law. And they took out, and it just, you know, whatever provision they'd had, and it just got smaller and smaller. And now it's just 2 paragraphs, and as provided by law. That bothered some legislators pretty much. They felt, well, you know, we were supposed to, it's our responsibility, we're just punting. Yeah, but it's punting right back to the legislature, I mean. So I wasn't too concerned about it personally. I don't get a vote, so maybe it doesn't matter. But I felt that, you know, this is the first time we actually got something out of that place that doesn't have to be signed by the governor. It only has to be approved by the voters in 10 years or 11 years. And I felt that it was good enough to get it out. It was going to have to be decided by the legislature and signed by the governor anyway at some point as a statute. And let's just do it after instead of before, when they don't have a choice anymore. Nobody can hold them hostage and say, well, if you don't include this, or if you do include this, I'm not going to vote for it. Well, or I'm going to veto it. Well, that's not going to happen because they have to pass it now. So I kind of like the way it worked, given the circumstances. But what are those things that may be provided by law? Well, it doesn't take a genius. All you do is look back at the original version and look at what they had in there, and then you see what kinds of issues that were of interest to the legislature in the first round will have to be resolved in the second round. So the questions that may be provided by law, terms and qualifications of commissioners, that's not in there. Lengths of their terms, whether their terms have limits, whether they're staggered, the length of their prior political party membership. There were provisions in the original version that said that you had to be a member at least for a couple of years of your political party so no one would switch registration just so they could get on this commission. It's kind of a long shot that anybody would do that, but I suppose they were concerned about it. Staggering, that's pretty obvious. I think you want to stagger terms like with any other body so you don't end up you know, with people all being turned over at the same time. The disqualifying conflicts of interest, that was dealt with at length in the first version. It included disqualifying people who had previous experience, at least within recent years, as a state employee or holding as a state office holder, employed as a lobbyist, a contractor. In some sense, it almost took away anybody who might really know what they're talking about. And you know, I thought it was kind of a little too much myself, but that's just my editorial comment. What other issues? Well, there may be a minimum number to take action, not just a quorum to convene, but actually a minimum number of votes required, like a supermajority, to take action in cases that are particularly sensitive of some kind. So that was in the original version. It's not there anymore. Staffing and funding, it does talk about, in the original version, it talked about having an executive director, and then at least it made a statement about having enough funding to do their job, and that's not in there anymore either. Removal of commissioners. How are we going to know what cause will enable some authority to remove commissioners? Who's going to do it anyway? What method? What kind of due process that they're entitled to? That's all left open for future to be provided by law. And the most important issues, I think, which laws are they going to oversee? Who can request advisory opinions? Remember, the advisory opinions are one of the few things that are in there now. And those are very valuable because those can provide guidance. one of the concerns I think we've seen with the Governmental Conduct Act and the Procurement Code, not everything is crystal clear when it comes to how to apply some of these provisions in terms of various situations. Well, advisory opinions from some authority serve two purposes. They provide guidance to the people involved and governed by these statutes or other rules. And secondly, it gives them a little bit of cover, because people who act in good faith but aren't quite sure if they're acting properly under the law because of some interpretation question, those people need some kind of reassurance that if they go ahead, that somebody has said that they've done the right thing. So I think advisory opinions can say, in our opinion, you are acting properly, and then you can go ahead and you won't be reviled and prosecuted and impaled or anything else. You will simply go ahead with some assurance that you're okay. Even if later on, someone takes it to court and says you violated the law, at least you acted in good faith because you tried. I'm on the advisory committee of the Code of Judicial Conduct, and we've had this advisory committee operating for many years. I've been on it since 2004 myself. And, that's exactly what we do. Judges have situations come up where they're asked to do, they're thinking about renting a building they own to a lawyer. The lawyer may appear in front of them. They ask us, can we do this? Does that disqualify me from all that lawyer's cases? And if so, does that mean I can't even rent the space to them? Questions like that. We give them back advisory opinions. We have all of those indexed. They're online. And judges can look at those, or they can make the request and they get an answer that at least they can use as guidance. And I've never, ever seen anybody prosecuted under the Judicial Standards Commission when they followed our advice. They may have modified it, but they've never held anybody accountable once they followed our advice. So that's important cover for them. What about rulemaking authority? The original version of the constitutional amendment provided that the commission would be able to adopt rules. That's not in the version now, and it's a big question because I think in the national level we've seen this controversy over the Consumer Finance Protection Bureau, where they've adopted some very powerful rules involving billions of dollars that they've recovered since they were first created, and now they've become a target and are really struggling in terms of whether they can even survive in their current form. So that is an important question about rulemaking. How much authority are we going to give a commission of 7 people who are appointed to make these decisions? And how valuable is that to have those rules to help clarify what's going on? Whether to extend the commission jurisdiction beyond state officials and employees. The constitutional amendment only talks about state officials or state employees. But for that matter, it does say, and otherwise as provided by law. But what if we decide to add counties or municipal governments? They're under the Governmental Conduct Act. What if we don't add them? If we don't add them, then we'll have rules or at least advisory opinions applicable to the people that the advisory committee, that the commission oversees, issuing advisory opinions. Will they apply to municipals and counties as well, even though they have the exact same laws applying to them? Questions we have to answer. How do we exercise power, or how does the commission exercise power over elected legislators and executive officials? So that's a really challenging one. Legislators are very jealous of their authority, no offense taken, I hope, to oversee their own members. And they have been very diligent about that, as witnessed the case we'll be talking about at the end. But what happens if this commission decides that it wants to hold some legislators accountable? How do they do that? And that's not to say these aren't answerable questions, but they are questions that need to be answered. I think that ultimately the State Ethics Commission can offer guidance to the officials, employees, and so on through the advisory opinions, through rulemaking authority if they get that, and through education in any case. Education that is I think, somewhat lacking in terms of understanding all the laws. Especially many staff. I teach classes in the Governmental Conduct Act for quite a few county and mostly county, but also other officials of local government. I've had hundreds take my class by now. And I ask, how many of you have actually had training in the Governmental Conduct Act? It applies to them. It's, they could be held accountable for violating it. Their organizations can be held accountable for violating it. And really very few have that much experience or training in it. So this commission could, for example, train trainers and then send them out to do the work. And reach out to everybody, or do it online, or do it through other forms of mass communication. I think the commission could also offer, okay, I have a little pop-up coming up here. I wasn't sure if you saw that, you didn't. They could offer consistency in advisory and enforcement standards. So we don't have the Department of Health and the Department of Homeland Safety and all of these different departments analyzing and interpreting and applying and implementing these rules and laws according to their own standards, some with a slap in the wrist, some by firing people, but rather that there would be consistency in how these things would be applied, because you'd have a single commission, just as the Supreme Court right now does for the interpretation of the Judicial Code of Conduct. They provide consistency, and it is pretty consistently applied across the board, and the Judicial Standards Commission. It would provide an independent ethical authority, not subject to control by anybody, not answerable to anybody except the people. A nonpartisan public disclosure of misconduct would be a source that would not be an opponent in an election saying my opponent has really done some bad things, but rather a nonpartisan disclosure by this commission, which is by definition bipartisan at least. They would not be suspect the way an opposing candidate would be in terms of the message that they may be providing. And it would provide a legislative mandate and resources, hopefully, for civil and administrative enforcement. Now, not criminal, because that's reserved by due process to the courts, but at least civil and administrative, and they possibly could be empowered to refer criminal cases to the Attorney General or district attorneys for prosecution, and I think that would be appropriate. Many commissions do. So what would the commission need? Well, the commission will need adequate staffing and funding. There have been versions of the constitutional amendment and then subsequently the statute that really gave them very, very broad powers. And that does have some very strong appeal and logic to it. The trouble is some of the tasks are so demanding and so time-consuming and so intensive, labor-intensive, that if they're not staffed adequately, those projects, for example, reporting requirements for elections during the campaigns, that could be overwhelming, and the staff could have no time to do anything else. So it's fine to assign whatever authority seems appropriate and whatever belongs in conjunction with the other work they have, but I would say as long as they have the additional funding or the necessary funding to cover the job. They need a strong but a reasonable mandate from the legislature and the executive to do what they're going to do. The mandate being in the form of that critical statute that we're not going to know what's in it unless the voters pass this, and we won't know it until the 2019 session. They need a consensus. The commission, excuse me, the commission needs to adopt a consensus position on its priorities. What are they going to prioritize so that they don't go off in different directions? We heard the mayor talking about people being pulled in different directions by the council by having 9 bosses, basically. Well, they need to have a consensus among the 7 members to make sure that they at least are on the same page in terms of what they're focusing on, because there'll be too much to do no matter how well they're staffed. Guidance from other jurisdictions. There are 42 other jurisdictions that have these commissions. So let's find out what they're doing. Some of them are remarkably effective. Some of them are very well staffed and very very innovative in how they approach these issues. and above all, an independent team of committed commissioners and staff who aren't going to be influenced by pressure. So let's turn now to the next thing that happened, and some really interesting developments occurred in campaign reporting. And I'm not going to focus on everything, there's too much to cover, but I just want to focus on one area of that, and that is the area that I alluded to at the outset, and that is campaign reporting, but particularly campaign reporting by donors to independent groups. Independent groups being groups that do not coordinate their expenditures with the candidate, with the party, with the campaign committee of the candidate, but rather go out there and do this on their own, run a campaign on their own, with the understanding that they will not coordinate and thereby not create a situation where the candidate is beholden to them. And under the Citizens United case, the critical difference is that independent expenditures are not subject to limitations. The Citizens United, for anyone who doesn't remember, was a Supreme Court decision in 2010 that decided that donations to an independent group that doesn't coordinate, those donations cannot be limited by law. And that struck down that section of the McCain-Feingold campaign law that had limited those, because they said you can't stop people from spending money in support of their own First Amendment rights to express themselves unless they're part of a campaign, and these are by definition not. So Senate Bill 96 attempted to address that issue. And full disclosure, I worked for Senator Wirth during the session, and I was when this was passing. Secretary of State Rule 11013 was subsequently proposed and went through a process of hearing and disclosure and was adopted. And it covered many of the same things. And then the other interesting aspect of this issue, which is why I brought it up, because it's state and statutory, regulatory, and local ordinance levels, is the application of Santa Fe City Ordinance 9-2.6. So let's go to each one of those. Senate Judiciary Committee substitute for Senate Bill 96 was introduced in the last regular session. The substitute bill, this bill, passed both houses by pretty overwhelming, or at least I'd say convincing votes, 36-6 in the Senate, and a closer but still convincing 41-24 in the House. But it was vetoed by Governor Martinez. And let's explore what was going on. And again, I'm just going to focus on this one aspect I mentioned because we don't have time to get into all of it. The key achievement of Senate Bill 96 was to distinguish coordinated and independent expenditures, define what they are as clearly as they could. Coordinated expenditures are those made in cooperation with the campaign, with the candidate, to support a candidate, or if it's not a candidate, a ballot measure, such as the constitutional amendments, or to pay for campaign advertising. But those are all coordinated, means that they are working with the candidate, the candidate's committee, the political party that the candidate is with, and therefore their contributions are subject to the campaign limits set by the law. New Mexico has those limits applying to these expenditures. Independent expenditures, by contrast, are those that are not made in cooperation with the campaign, and they can only reasonably be understood as supporting a candidate or a ballot measure. So you have the minimum threshold that they are definitely meant to help a candidate, but they're not made in cooperation with the campaign. And then it's done within certain time frames that are in the statute I won't get into. So what would SB 96, had it passed, or had it been enacted, it did pass the legislature, would have required that coordinated expenditures, they had to be disclosed to the Secretary of State, and they were subject to contribution limits. That's pretty straightforward. The independent campaign expenditures could not be subject to contribution limits, as I mentioned. But the bill would have required disclosure of funding sources. And if you read Citizens United, you'll see that Justice Scalia first said expression of free speech. We can't put a limit on, nobody can put a limit on the amount that you can spend in support of your free speech rights. No limits are authorized, they're struck down. But there is an offsetting check, and the offsetting check is disclosure. You can require that the contributions be disclosed as a way of at least telling the voters, we can't stop these people from giving $1 million, but we can make them disclose that they are the source of that $1 million contribution. And that means that you then find out who's backing a candidate or who's backing a ballot measure. Can anybody think of an example where that might have come up in Santa Fe and been sort of significant? Yeah, I mean, if we didn't have the city, just to jump ahead, if the city's ordinance hadn't provided this, you wouldn't have known that the $1 million that Pre-K for Santa Fe spent on, or at least got to spend on its sugar tax campaign, that was $1 million that came from Bloomberg. You wouldn't have had any idea where that came from. But we had the disclosure requirement. Conversely, you wouldn't have known that the Better Way for Santa Fe campaign, which was opposed to the sugar tax, you wouldn't have known that came from the American Beverage Association. Okay? Is that relevant information? I think so. I think it's relevant for people to know who's supporting this. And then that helps them make up their minds because it's disclosed. Well, without this kind of requirement, they're not going to know. And, you know, if anybody thinks that this is only important for candidate elections, because there is an argument, well, candidates can be corrupted, right? If I'm running for office and somebody gives me $1 million, they're going to get pretty good access to my office when they show up to ask for something, right? But, you know, a ballot measure, there's no one to bribe. There's no one to corrupt. You know, it's just a law. It's either going to happen or it's not going to happen, and there's nobody that you're influencing personally. That's an argument that's been made against applying these rules to ballot measures. But the fact remains, as we learned in Santa Fe, it is relevant to people on how they vote. So Senate Bill 96 for the state level elections would have said that, yes, they're not subject to contribution limits, but it would have required disclosure of the funding sources. And specifically, it would have required the disclosure of independent expenditures over $1,000 supporting candidates or ballot measures, who the funds were paid to, and the purpose of them would have all been required. And that was all passed by the majority of both houses. It would have also required disclosure of sources of funds if the total of expenditures were $3,000 or less. Then you simply have to disclose each contributor of $200 or more. Now, what I'm saying there is, if there's an independent group that has a name that's kind of innocuous, you don't know what the name means. You know, Citizens for a Better New Mexico. Well, you know, where do they come from? You know, where do they believe in? Who's supporting them? Well, you'd like to know that. So if Citizens for a Better New Mexico gave money to a candidate or to a ballot measure, and if the expenditures were $3,000 or less, they still have to disclose each contributor to Citizens for a Better New Mexico who contributed at least $200. Okay, so you didn't want to just bury the real contributor. You didn't want them buried by some innocuous name. You wanted to know who they really were. If the contribution were earmarked to or solicited for this particular expenditure. If the total expenditures were greater than $3,000, you have to disclose each earmark contributor of $200 or more, once again, but you also have to do one of two things. Either segregate all the earmarked contributions, all the contributions that this Citizens for a Better New Mexico has received, segregate all of those that are earmarked for campaign expenditures and report the sources from that of over $200. So again, you couldn't just bury that stuff. Or you had the alternative, just report every contributor to Citizens for a Better New Mexico, whether they earmarked the money or not, but only $5,000 contributions had to be disclosed, $5,000 during the election cycle. Okay, so it got kind of convoluted, but the point was not to let anybody hide their donation to this group that's supporting a candidate or a cause, not to let them hide it by simply, you know, basically whitewashing it. and laundering it, I should say, and saying it's going to go to this group that doesn't have a name that nobody can associate with any particular cause. How am I doing on time? Oh, yeah, there it is. Okay, so the bill would also have required disclosure of a funding source to appear on all advertisements. Okay, now there are exceptions where it's impractical. You can't quite expect people to put a to say this ad sponsored by so-and-so when it's skywriting, right? Or on a water tower or on a matchbook, so there's things like that don't require it, or a pen. But basically, on a regular advertisement, on a piece of paper, a flyer, it would have to disclose the source of the funding, even if it's an independent source. So the voters would know the sources. They would especially know who the large contributors are, either for candidates or ballot measures. That was the passage of Senate Bill 96. Okay. So the governor's veto message said, well, I support transparent political processes, but she said that there are unintended consequences by Senate Bill 96. What are those? Well, it forces charities to disclose their contributors in certain circumstances. Yeah, if the charity decides to engage in political activity, yeah, they should be disclosed. I'm obviously not very partial to this, but or a second objection is it would likely discourage charities and other non-political groups from advocating for their cause. In other words, if they don't want to disclose who their donors are, then they aren't going to say anything at all because they're afraid of exposing their donors. Well, man up, I mean, just if you're going to get into politics, it's a rough game, that's what you have to do. It could also discourage individuals from giving to charities. Those were the arguments made. That's, I think that's what happens when you get veto message arguments. That's what you get. So it got vetoed. It's not the law. But it did. Why did I waste 13 slides on this and all this time? Well, because the Secretary of State was waiting in the wings. We knew this would very likely happen, and the Secretary of State proceeded to adopt Rule 1-10-13 of the Campaign Code, which says essentially the same things as SB 96. There are differences, but they're not worth getting into here. The threshold, for example, for statewide races to require disclosure now is up to $7,500. But otherwise, the required disclosures that the Secretary of State adopted were pretty similar. And of course, it allows civil penalties as allowed by statute, but there the legislature is required to act and authorize that. So the Secretary of State's rule was subjected to multiple hearings, public hearings. They were held. Many comments were sent in. There was quite a bit of opposition from people who felt they were afraid of being intimidated if they fessed up and opened up that they were making contributions. And in fact, there was the NAACP case from the, I think the 70s or 80s, where donors were afraid to have their names revealed when they were donating to civil rights causes because they were afraid of retaliation from KKK. So, they had an argument. But SOS Rule 1-10-13 is currently in the books and has not been challenged. I just checked yesterday to make sure I was right about that. It has not been challenged by statute, by a court case. So what about Santa Fe? Well, Santa Fe City Ordinance 9-2 is the campaign code for Santa Fe. And 9-2.6 provides for disclosures. And we have this in effect for Santa Fe to some extent. We have disclosure of expenditures of over $250 by the independent entities themselves. So, that mythical group, now let's call it Citizens for a Better Santa Fe, they make a donation not directly to the campaign, not to the candidate. They just go ahead and actually go out and put out their own ad. Okay, that, if it's over $250, they have to disclose that with the city clerk if it goes out to over at least 100 voters. And that includes reporting contributors to them. And there's no minimum on that. maybe there should be, actually. Jim Harrington and I go back and forth on that a little bit, but basically if there's no minimum at all. Anybody who contributes to that group, which then in turn contributes at least 200, when I should say expends, not contributes, expends $250 on a candidate or any campaign, that has to be disclosed, as well as the name of the contributor to the group. And City Code Section 9-2.3I says that independent entities must disclose both their expenditures and their cash and in-kind contributions that they receive. Okay? And that was critical, because the Rio Grande Foundation, during the sugar tax campaign, ran some independent ads against the soda tax on behalf of Better Way for Santa Fe. They spent less than $250 on their expenditures to make sure that they did not fall under or they did not exceed the threshold for disclosure. And they were right about that, and we wouldn't have held them accountable, we being the ECRB, the Ethics and Campaign Review Board. But they also received a free anti-tax animation, a little cartoon, that they ran on the internet. And a lawyer, retired lawyer who's living in town here, spotted that, came in, brought in evidence that, that in fact that little anti-tax animation had to be worth at least $3,000 and in cost. In fact, he brought in a witness to testify to that, a producer or a animator. And so they didn't disclose the source of the in-kind donation, and that was challenged by him under our ordinance. We did find that to be a disclosure violation by the Rio Grande Foundation, because they had received, between the animation that they were putting up on the web, and that was seen by over 100 people, and the money that they themselves had put in, they were well over the $250 threshold. So we told them that that was a violation, and we just, we understood that they had a question about it, so we just reprimanded them. We didn't fine them or anything. We said, well, let's get this precedent set, and they complied. They did disclose who the source of the animation was. But then they filed a lawsuit for declaratory and injunctive release so that that wouldn't be enforced further, and that is a pending case. So what's going to happen to that case? Well, it's pending in federal district court. They sued because they were required to they didn't challenge what we'd already done, they just challenged prospectively doing it again. The City Council is at least considering, and has on its agenda for December 13th meeting, a proposed amendment to the ordinance taking out the disclosure requirements that we've been talking about for ballot measures, not for candidates, because the Rio Grande Foundation isn't challenging, it doesn't ever endorse candidates. They just came in on the ballot measure alone. So that's maybe on the agenda for the 13th. There's some other possibilities being discussed, so it may not end up there. But in any case, that we have the ECRB has unanimously recommended against that because we don't think that that we should let people sue us for perfectly legitimate and defensible actions that we've taken. And therefore back off just because of the suit being filed. I think the suit is going to lose. So anyway, let me just conclude with and give you a little time for questions with the case that you're familiar with, and just maybe get you a few details about again a very sad case of State versus Phil Griego, the state senator. Again, I take no joy in this, but I just want to. It is on the record, and I want to make sure we know about it. The allegations again, and actually there's very few disputed facts in this matter. Really nothing, very little of significance was disputed. Senator Griego became involved in the sale of a state building to a private hotel owner. You probably all read this in the New Mexican or the Journal. Legislation was required to make that transaction happen because of the amount involved. It was over the $100,000 threshold. There was an unwritten agreement with the purchaser between Senator Griego and the purchaser to the effect that he would be their realtor. And I don't know if they actually discussed the exact amount of his fee, but it was clear he was going to personally benefit. he had other legislators introduce and present the necessary legislation, the legislation that was needed to get this done. And after the bill passed, he did sign an agreement for a $50,000 commission on the transaction. So the primary acts that he was accused of for violating ethics laws were failing to disclose his personal financial interest in the sale to his legislative colleagues, attending hearings, legislative hearings, without correcting misinformation. And the misinformation that was not corrected was that it was stated mistakenly in a legislative fiscal impact report. It was stated that there was going to be a net benefit to the state by selling this because the state was paying a lot of money to maintain the place and keep it up and repair it. And in fact, that was not happening. And he knew that it was not happening. The potential buyer was already renting the place and was doing all the repair themselves and all the maintenance themselves. So he also advocated for expedited legislative action, and he pressured the Capitol Building Project Commission chair, then House Leader Martinez. He pressured them and their staff to reconvene a meeting of the commission when they had met and not yet addressed that issue to make sure that the time didn't run before the legislative session was over. Well, Senator Griego from the outset admitted, yeah, there was an obscure constitutional prohibition I didn't notice. And he said it was Article 4, Section 28, which prohibits a legislator's interest in a contract with the state which was authorized by any law passed during the legislator's term. Clearly, that he knew that was violated, and he basically admitted that as he, you know, the Senate Ethics Committee approached him on this. He went over it with them, and the result was he resigned from the Senate, and that was, I think, the first thing he admitted. But that's not a criminal violation. The criminal convictions arose in fraud, 1 count each of fraud, bribery, having an interest in a state contract, and 2 counts of violating ethical principles of public office. And for 2 of those statutes, they're very similar. The first I've got up there is the unlawful interest in a public contract that says basically if you receive anything of value from a purchaser in connection with the sale or purchase of lands or anything of value by the state, you've violated this statute. Well, there's just no way out of that. He got something of value. And the ethical principles of public service, no legislator may receive any money or promise thereof conditioned upon or given in exchange for promised performance of an official act. One of the only things that I've seen in the that was disputed or at least questioned to some extent was whether he actually cast a vote during the Senate vote on this. And he remembered that he had left the room, but he was shown on the register as having voted in favor of the transaction. But whatever, there was enough there that he was obviously guilty. He's going to be, I think, and the jury agreed, and he's going to be sentenced in February. But my question is, what will the public take away from this case? Well, it's going to be one of 2 things. And I think it's important for public officials and those of us in the bar to think about how do we want to weigh in on this? What kind of message do we want to send? Was it that the system worked and this one official who did something that was inappropriate, and he was held accountable for it? He did something corrupt. And he was held accountable. It was a lesson to everybody. He was prosecuted. He's going to at least get sentenced to something. And of course, he's got other charges pending against him too. Or will this say, yeah, I see, they're all doing it, and they just got this one? And I really hope it's the first. I hope it's because I can tell you that I was working at the legislature at that time. I did not know what had happened. I just knew that Senator Griego had resigned very suddenly and abruptly, and all I was hearing, nobody was talking, nobody was telling me anything, and they shouldn't have. They were had great integrity in not disclosing it. What they did say was it was really bad, and they all knew that this was criminal action, and they knew that well enough to say this is just not acceptable, and we have to stop, and I have to stop. Nonetheless, it was true that The public can see these things in different ways, and I think one thing we want to take away is that we do want to try to we want to try and send the right message that this was not a typical act in the legislature. So this is what lies ahead. These actions are still what face us. I think the most exciting one, of course, is if the constitutional amendment passes, and then what happens in 2019. And here's a little quote I like to end with. You can just look at it yourself. Thank you.
Thank you, Paul. And we did leave time for questions. So do people have questions?
Except for Jim. He knows too much.
This isn't a question. This is an announcement that Councilor Dominguez, who is the lead sponsor on the attempt to change the disclosure law in Santa Fe, has said it will not be heard on the 13th. It will be heard in January because, as you may know, Santa Fe only has one council meeting a month in November and December, and there's just too darn much on the agenda to take this up as well. So it'll be heard in January, and if we're lucky, it won't be heard at all because he has gotten enough pushback on it that he may pull it.
Thank you. I didn't.
Thank you for that, Karen. So if you were planning on going, you can change your plans.
So this is just to show how young Paul is, but NAACP versus Alabama was 1958.
Oh, shoot. And I remember it.
It seems like the 70s, though.
Thank you.
Any other questions? If we don't, then I guess we can go. I would like to take the time to thank you all, our audience. The participation has been great. We really enjoy doing this event, and it would be nothing without you. So tell your friends, come back next year. Tell your friends to come next year. And please don't forget to fill out your CLE forms and your evaluations. There's a box right there up front. Leave them all there. You can flip them over so that nobody sees what you said or thought. And we do look at them all very carefully and figure out where we can improve. So thank you.